Any mention?
Yes.
May I please, Your Lordship? I beg to mention item number 11.
11. Do you know?
Yes, my Lord.
I have no objection, Lord.
It's for hearing.
It's a criminal appeal, Your Lord.
After
After 3 weeks, my Lord.
3 weeks.
Yes, my Lord.
Yes.
Lordship, no objection. Apply, Your Lordship.
My lord, item number 9, my lord. I am for the petitioner, my lord. My lord, I've been instructed, my lord, to take some time because they will put this matter in the EC
withdraw the
meeting.
appeal?
Yes, my lord.
You withdrawing the appeal?
No, not withdrawing, my lord. They will decide in the EC. So after that, if this matter can be heard, my lord.
Let it come. I'll get instruction.
They'll come after 4 weeks, my lord.
4 weeks.
Yes,
Wait too
because,
long.
because now, my lord, they are the one who is holding strike, my lord, in the office. We cannot enter
No,
even.
Lordship, I'm no more in service. I have nothing to do with the strike because there's some other
That's
people.
why you're holding a strike.
No, not me at all. I am already not in service anymore.
What are you doing
Simply
now?
and blame.
You're
I'm
from
staying at
behind,
home. No, it's just a case saying that I'm behind. I have nothing to do. This is just an allegation against me. Let it come after 2 weeks,
My
Lordship.
lord.
3 weeks.
3 weeks.
Lordship. Much obliged, Lordship.
That is submitted that the matters under active consideration of the Executive Committee. Let the matter stand over for 3 weeks. Yes.
Lordship. Much obliged, Lordship.
May it please, Your Lordships. Lordships, I beg to make a mention of item 10.
I'm for respondent 2 and 3, Your Lordship.
Lordship, I pray if this matter may come up after 2 weeks.
What's the matter about?
Lordship, it's an income tax
Tax
matter.
matter.
Lordship.
You've come from outside.
No, Your Lordship. I'm on behalf of Shankar Pandey, Your Lordship.
2 weeks, okay.
Highly obliged, Lordships.
So where's this?
Item number 1.
One second. Yes.
No, Lordship, I am for the respondent number 2 and 3, Income Tax Department, Lordship. Sir, kindly allow us some time to file our affidavit, Lordship.
You're for which matter? Item number 4.
Item 4, Lordship.
Yes,
After
Remington Gabel movement.
Yes, Lordship.
What's the matter about?
Lordship, it's an income tax matter. Assessment order has been passed.
Yes, you are Mr. What? Chetia? No.
JP More, Lordship.
Mr. JP Moore. Counsel for the respondent. Please further how much? 3 weeks time.
3 weeks time, Lordship. 3 weeks.
File affidavit just thereafter.
Lordship, interim may be extended, Lordship.
Interim order of any shall continue until the next day.
Highly obliged, Lordships.
Obliged, Lordship.
Hearing, item number 5.
Lord, item 5 and item 7 and 8 are connected. The Lordship has heard us on item 5.
Yes, sir. Dr. Saraf wanted to make some submissions in reply to some affidavit filed by. Give the item number.
7.
Dr. Mosika, yes, 5. We are hearing Dr. Saraf's matters. Which one?
Number 7.
7, madam.
7. Item 7.
Yes.
My lord.
Where were we last time?
My lord, I will just summarize 2 points which I argued before Lordship in the last day, you know.
Yes.
First submission which I advanced before Lordship was that, you know, Section 39, power of the scrutiny of returns. When we made only in the cases where the notice has been issued by the Commissioner under Section 35 of the Act,
Yes.
which is clear from the language of the Section 39 itself. Even if your Lordship may kindly take Section 39 once, my lord.
Where, which page, where you have been exited in your petition?
Petition, Section 39 quoted.
It's quoted, yes.
So Section 39 has been quoted at page 15, my lord.
1.5.
1.5.
Yes.
Each and every return in relation to any tax period furnished by a registered dealer to whom notice has been issued by the Commissioner under Section 35 shall be subject to scrutiny by the assessing officer to verify the correctness, calculation, application of the correct rate of tax, etc. etc.
Yes.
So, my lord, issuance of a notice under Section 35 by the Commissioner is a condition precedent
Yes.
for the exercise of the powers under Section 39 of the Act.
Yes.
Now, in the present case, my lord, no notice under Section 35 was ever issued to the petitioner,
Yes.
and thereby the precondition for the exercise of the power under Section 39 has not been fulfilled.
That's the only point. Next point.
No, my lord. Now, in this connection, my lord, the respondents have relied on a notice which you also find at page 14 of the affidavit of opposition, my lord.
Page
1.4
of the affidavit of opposition.
of affidavit of opposition, my lord.
The first affidavit.
No, this is the first affidavit.
Page 13.
This is 14 type copy, my lord.
Page 13. Page 14.
14 is the type copy, my lord, notice
Yes.
dated 27/4/2017.
Yes.
Has you also got it, you know?
Yes. Yes.
Now, this is your notice, your lordship kindly read, my lord. I may read, my lord. This is notice dated 27/4/2017.
Yes.
With reference to the subject cited above, you are hereby reminded to produce in the office of the undersigned the books of accounts noted below for the period ending so and so under the Meghalaya Value Tax Act, positively failing which assessment for the above periods will be completed to the best of judgment without further reference to you. And the books of account which are required to be produced is mentioned below.
Yes.
Now this notice, you will also find, this is for the purpose of making of the assessment. Now this power of direction for books of account is contained below in section 55. Lordship, you have to take the book below because
Yes, we have the book.
My lord. 55 is the audit assessment below.
Yes.
Now, you know, some kindly see below. I will take it directly to the D below, 1D.
Yes.
The commissioner has, if the commissioner has reason to believe that detailed scrutiny of the case is necessary, the commissioner may, notwithstanding the fact that detail may have already been assessed under section 54, serve on a dealer in the prescribed manner a notice requiring him to appear on a date and place specified therein, which may be his place of business, a place specified in notice, to either attend and produce or cause to produce the books of account and other evidence on which the dealer relies in support of the return, including tax invoice, if any produce such evidence is specified in the notice. So, many of the books of accounts, documents, and papers are directed to be produced only when an audit assessment is taken up.
Under 55. Yes.
Under 55.
Yes.
Section 39, you will also find there is no provision for production of the books of accounts and documents because that is a scrutiny of the assessment.
Okay.
So this notice
cannot be 135.
My lord, your lordship, on the last one's occasion, my lord, that if the notice by any state of administration can be treated to be a notice under section 35 by the commissioner, then your lordship may also treat it in that way. And your lordship may also see section 35 once again, my lord, that why the commissioner will issue the notice. You will also can see subsection 35(3). Any dealer other than a registered dealer referred to in subsection 2 shall, so required by the commissioner by a notice served in the prescribed manner, furnish returns in accordance with the provisions of subsection 2. So this
is a case of registered dealer, you know, this provision is not applicable.
Mr. A.G. kindly, I will, when I am submitting something, I'm not
because 3 is with
I'm submitting.
Please continue. Please proceed, Mr. Dr. Sarah. Please proceed. Yes. Let's not digress. Yes.
No, the subsection 3 below, the notice is for the purpose of the furnished returns in accordance with the provisions of the Act. Now, you're asking me once again take the trouble of looking at section 39.
Yes.
It says that each and every return in relation to any tax period furnished by a registered dealer to whom notice has been issued by the Commissioner, section 35. Now here the word used is registered dealer, whereas 35 says, you know, that a dealer other than the registered dealer.
Yes.
Now, I will make a submission on this below.
Then how do you reconcile it to provisions then? If 39 speaks of contempt notice at section 35, furnished by registered dealer, and 35(3) says any dealer other than registered dealer. How do you reconcile this?
I will make a submission below.
Yes.
Below section 35(3) says that a person who is a registered dealer,
Yes.
if so required by the commissioner by notice and solicitor to furnish the returns in accordance with the law. Now, a dealer can submit a return only after getting himself registered. Now, a commissioner may issue, if the commissioner finds that person concerned is carrying on the business but he is not registered, he has not submitted the returns, the commissioner may direct him to submit the returns in the prescribed manner. Now, your lordship is aware, my lord, the returns can be submitted only when the person gets registered. So, first of all, he has to get himself registered. Now, section 39 says.
No, please come back to 35(3). What do you please explain? We're just trying to understand. What is any dealer other than registered dealer? Now, where is the distinction, Dr. Saurav? Why they made this distinction? Why have they said any dealer other than registered dealer?
This is the reason, Lord. First of all, your lordship may have to see, Lord, first. First of all, Lord. The tax payable under the Act shall be paid in the manner prescribed. That's 2, Lord. Every registered dealer shall, in the prescribed manner, furnish such returns by such dates and to such authority as may prescribe. So, every registered dealer has to submit his returns in the prescribed manner. They done in 62. Now, the commissioner may come across a dealer who is not registered, Lord, who has not got himself registered, and he may come across the cases where a person has not got himself registered, and he may direct him that he is carrying on the business, so to file the returns in the prescribed manner. Now, when such a direction is issued, Lord, to file a return, then that dealer had to get himself registered and only submit return. Without registration, a person cannot submit the return.
That is what?
My lord. Now, section 39 says, my lord, that every registered dealer, because by that time he will become registered. Once the commissioner has issued him a notice to submit the return, my lord, then.
No, but he cannot serve notice on a registered dealer.
My lord, it says, my lord, you see, a person registered whom notice has been issued by the commissioner under section 35
yes,
shall be subject to scrutiny. You know, the reason behind, I will also explain, you know, I will just take it also. The reason behind is that, you know, a commissioner has issued a notice to a particular person to submit the returns who are not registered at the relevant time. Now, such returns are subject to scrutiny. Section 39 only contemplates a situation where a person has submitted the returns in pursuance to a notice issued by the commissioner. Now, such persons can be only stated to be under section 35. Now, your lordship may also.
No, we understand your argument that a section 39 notices presupposes the service of section 35 notice. Now, your argument is that that notice which they claim to be a section 35 notice is not a section 35 notice because 39 does not contemplate, the production of documents, and so that 55 is also governed by section 54. That's the only thing, yes. So you say that that notice in the face of it, a plain reading shows that it cannot be taken to be a section 35. So the section 39 notice is incompetent. That is your argument, correct? If we understand it correctly. Now, things that only we can't understand is the wording of this section 35. If before any that's the only thing. It's only for our own enlightenment. At least we have to understand. That's the only thing.
Section 39 section, in my humble submission, is not happily worded.
Okay, yes, maybe yes.
But your lordship is aware, my lord, that in a taxing statute, my lord, the act has to be treated, has to be construed very strictly.
Yes.
Now, strict construction means, my lord, that a person to whom a notice has been issued is a condition precedent. Now, if that notice has not been issued, then section 39 powers cannot be exercised. Now, I place before lordship, my lord, a decision of the Tribunal High Court, my lord, exactly on the same issue, my lord.
No, you can't understand this 35.3.
My Lord, I really appreciate I am with your Lordship about that. The language of section 39.
My Lord, section 39, if I can.
No, let Dr. Saraf finish. Let him finish.
We'll
give you ample time, Mr. Sinkan. No need to jump the gun.
Wait. Mr. Sinkat, please wait.
Yes, where is that judgment?
The district judgment in WPC
I think
847.
it was supplied to us earlier.
Yes, yes, Lord. Yes, also.
Pankaj Bihari Saha.
Well, Pankaj Bihari Saha.
Yes. This mega thing is fascinating.
Kota say. Lord, here also, you'll also find the section I just placed for Lordship.
Para 12, para.
Well, para 13, para 12 was the section,
Yes.
Section 27 of the Tripura Value Tax Act pertains to scrutiny of the returns. Subsection 1 of Section 27 provides that every return in relation to tax period.
This is parameter section. This is parameter section 39.
Exactly.
Okay.
And you'll also find the observations of the Honorable Court below.
Yes.
At para 16 below.
Yes.
Chapter 5 of the Tribunal Value Tax Act that provides.
Where reading from?
Para 16.
Yes.
Chapter 5 of the Tribunal Value Tax Act that provides for a complete mechanism for filing of the returns, their assessments, provisions for limitation of exercising the powers of assessment. Once a dealer files a return, it may be subject to different kinds of treatment.
One second, Dr. Saraf. I think paragraph 16 reading of this. This is downloaded from what? No, which one are you reading? Because you just read from the top of para 16. Doesn't tally. Can you kindly read?
Chapter 5 of the.
No, 16. We're reading something else.
There are two judgments of the Pankaj Bihari Saha. I am relying on 849, 847.
Same 1109.
My Lord?
No, where's the others? The two red petitions. See, Dr.
No,
Mozia,
no,
is not what Dr. Saraf's reading is not matching with our copy.
I will also see. There are two judgments. One you will also see 1109.
Yes, 1109.
1109 you will also see para 12.
Para 12, yes.
Section 27 I may just.
Pertains security of returns and these is under.
Under furnished by dealer to whom a notice has been issued by the Commissioner under Section 24 shall be subject to the scrutiny by the assessing officer to verify so and so.
Yes.
As you also got below?
Yes, that's the para 12.
Thereafter, my Lord. Thereafter, the court has dealt with the limitation point of the assessment, and I will take your lordship to para 15.
15. Yes.
My Lord. All the provisions noted contained in Chapter 5 of the Tribunal Value Tax pertains to return assessment, thus provide for detailed procedure for requiring a dealer to file periodic returns of a turnover for audit assessment of returns sold here, and also to address the issue of turnover restriction assessment. The relevant provisions of Section 24-27 needs to be looked into from the angle of the scheme contained in Chapter 5 of the Tribunal Value Tax concerning return assessment. Subsection 1 of Section 24 requires every registered dealer to furnish the returns in such form by due dates as may be prescribed. A registered dealer is thus obliged to file a return as mandated under section so and so of the Act. Subsection 2 of 24 of the Act refers to a class of dealer in respect to whom the Commissioner is to believe that his turnover sales exceed the taxable limit, and the Commissioner will serve a notice in the prescribed manner, requiring such dealer to furnish returns as if he was a registered dealer. Subsection 2 of section 24 thus covers the case of a person who may not be a registered dealer, but in his case the Commissioner is to believe that his turnover sales has exceeded turnover. Section 27 of the Act pertains to scrutiny returns. Subsection 1 of Section 27 provides that every return in relation to any tax period furnished by a registered dealer to whom the notice has been issued by the Commissioner under Section 24 shall be subject to the scrutiny by the assisting authority to verify the correctness of the calculation, application of correct tax rate, interest, input tax credit claimed by him, and full payment of tax and interest payable by dealer during such period. Subsection 2 of Section 27 provides that a mistake is detected in the scheme formula may come to 18 million.
Yes.
Section 27 of the Act is thus not a provision for full assessment of the return filed in response to the notice issued by the Commissioner under Section 2 of Section 24 of the Act. It is merely for the purpose of verifying the correctness of the necessary details a dealer furnished in such returns, and such as calculation, application of the rate of interest, etc., as well as the amount of tax and interest by such dealer, if any error is detected in these aspects. Under Subsection 2 of Section 27, the Commissioner would issue a notice to the recovery of demand payable extra tax with interest. These powers are essentially in the nature of prima facie adjustment. The provisions contained in Section 27 of the Act are vastly different from the provisions of sale assessment under Section 29 and provision assessment under Section 30, and most significantly, the audit assessment under Section 31 of the Act. The special powers can be exercised only in relation to a dealer to whom notice has been issued by the Commissioner under Section 24 of the Act. Section 24 refers to the issuance of notice only under Section 2 of the Act. Necessary, therefore, unless and until such a notice is issued under Section 2 of Section 24 of the Act, the tributary authority cannot invoke the powers under Section 27 of the Act. Any other view would defeat the very scheme of the said chapter, providing for audit assessment, limitation for completing such assessment, provided for in Section 33 of the Act. The respondent authority cannot be allowed thus to circumvent the limitation provided for completing the audit assessment by permitting resort to the powers of summary adjustment under Section 27, which are equally in nature and are available only in the cases where notice under Section 2 of Section 24 of the Act has been issued to dealer in the result, impugned orders and so and so are set aside and so and so.
Yes.
So in my humble submission, Section 27 of the Act being parameter
To Section 39.
to 39 of the Act, and in the present case also, no notice under Section 35(2) of the Act having been issued by the Commissioner, which is also apparent from the copy of the notice which has been issued, which is clearly not a notice under Section 35 of the Act. Thereby, in my humble submission, the notice and the proceedings which have been taken by the authorities under Section 39 of the Act are illegal and without jurisdiction.
Yes. Do you want to refer another last date? You wanted to reply to the authorities which are placed by the Advocate General.
Well, Lord Advocate General has not.
I have not commenced my argument. I have not commenced.
In this case, he was submitting in the case of Mojika's case. I think so far I remember.
So far as this case is concerned, I have not commenced my argument in this matter.
Okay. Yes. Please start.
You're
finished, Doctor. You're finished. Anything else?
No, 2 points more weighted, which I want to make submission for.
Yes.
One was the limitation point,
5 years.
The 5-year period. See, if philosophy looks into the provision, that does not cover Section 39 of the Act. 57 if philosophy looks into it.
Section
57.
Yes. No assessment after 5 years.
Well, it says no assessment under section 55 or 57 of the Act shall be made after expiry of 5 years. So it only speaks of 55 and 57.
Yes.
There is no limitation provided for under section 39 of the Act.
Yes.
Now, in this connection, my lord, where no limitation provided for,
What will be reasonable time?
by the year the lordship looks into the judgment of the Apex Court, my lord, in 2007 11 SCC 363, my lord.
Yeah, that if there's no time prescribed, reasonable time should be. Where's
My
the
lord,
judgment?
after discussion in paragraph from paragraph
Yes,
15,
yes,
the conclusion which has been arrived at, my lord,
yes.
is paragraph 23, my lord.
2007 11 SEC
My lord.
363. Para 15 16.
My lord, I just, if you also permit me, my lord,
Yes.
paragraph 18, if you also just 20, my lord.
Yes.
17. A bare reading of section 21 of the Act would be that although no period of limitation has been prescribed, therefore, the same would not mean that the Shiomoto power can be exercised at any time. It is right that if no period of limitation has been prescribed, a statutory authority must exercise the jurisdiction within a reasonable period. What, however, will be the reasonable period would depend upon the nature of the statute, rights, and liabilities, and others also. The reasonable jurisdiction or opinions should ordinarily be exercised within a period of 3 years, having regard to the purport in terms of the said Act. In any event, the same should not exceed the period of 5 years. The view of the High Court that this cannot be the unreasonable reassessment for reasonable period, keeping view the discussion made must be found to be a statutory scheme as indicated herein. Maximum period of limitation provided also is 5 years. Now, this has been set to 5 years below because of the reason that the maximum period for reassessment for recovery under the Act is only 5 years.
Okay.
Under the Tripura, under the Meghalaya Act also, below, the maximum period is 5 years, even for the purpose of reassessment.
Yes.
There is no, beyond 5 years, there is no period prescribed for the completion of the assessment.
Okay. Yes.
Now, in this connection, if you also look into the decision of the another decision of Tripura High Court in WBC 847 of 2020.
847. Okay. Same person.
Same person, Lord. But what happened in this case, when the High Court set aside the order in section 27 of the Act, then the assessing authority thereafter proceeded to make the assessment under section 25 of the Act. And that was a subject matter of challenge.
Yes.
Now, in this case, my lord, the lordship will find that the Tripura High Court came to the conclusion, my lord, at para 16, my lord.
Yes.
I may just Chapter 5 of the So-and-so Act thus provides for a complete mechanism for filing of the returns, their assessment, provisions for limitation for exercising such powers. Once a dealer files a return, he may be subjected to different kinds of treatment depending on the situation and the treatment that the assessing officer chooses to accord to it. He may either choose to scrutinize the return under section 25 if conditions contained therein are satisfied, or the return be selected for audit assessment, in which case the assessing officer can scrutinize the return of the assessee and make necessary adjustments as found appropriate. If there is a case of turnover respecting assessment, or have been underassessed or assessed a lower rate or grant of wrong or excess deduction of the credit, the assessing authority can restrict resort to the powers contained in Section 34 of the Act. However, one significant aspect in the matter is that the power of audit assessment as well as the assessment case of turnover assessment both can be exercised only within the period of limitation prescribed in the relevant section. We have noticed that as per Section 33 of the Act, no assessment under Section 31, that is, audit assessment, can be made after the period of 5 years from the end of the tax period in question. Likewise, as per the provisions of Section 2 of Section 34, powers of the assessing officer is cutting assessment cannot be exercised after expiry of 5 years from the end of the year in which respect of which the part of which the tax is assessable. It was in this context that while examining the previous exercise powers of the Section 27 of the Act, this court has made certain observations in the portion of which we noticing that once the assessing authority missed the time limit for carrying out the audit assessment or bringing the turnover taking assessment, the power in the Section 27 cannot be exercised, that too without satisfying the preconditions in the nature of Section 34 having been issued, the action is quashed. It was at this stage the assessing officer once again tried to bring the tax by some element of petitioner's turnover, which according to him is kept assessment. The dispute between the petitioner and the department with respect to the correct assessment is that the petitioner, the discounts allowed by the petitioner were correctly not included in the taxable turnover. The assessing officer, however, holds the belief that such discounts to be verified at any case and must have formed part of the taxable turnover. In the present case, we are not required to go, therefore not inclined to go into the correctness of the liable persons, but proceed on the basis there is a bona fide genuine dispute between the assessee and the department respect of the sale price form part of the taxable turnover. Such a dispute can be resolved only through the assessment in terms of the various provisions also. The same under circumstances cannot be subject matter of adjudication under Section 25 of the Act. We may recall under Section 1 of Section 25, the assessing officer can charge tax for dealer prescribed date if the dealer fails without cause and its amount of tax due as per return or punishment also. In the obviously in the present case, the department does not argue that the assessee petitioner fails in any of the categories of Section 25 of the Act. In fact, according to the department, the case of the petitioner falls in 24. There is a clear misconception on the part of the assessing officer whose powers in Section 1 of 25 of the Act that 1 of 25 can be activated when a dealer has not paid the tax at the prescribed date without sufficient cause, which tax liability emerges from the return filed. If there is a legal dispute about the discrimination of taxable liability turnover or other claims made by the assessee, the same cannot be subject matter of demand by the assessing officer under clause A of Same Act. Any dispute as to correct taxable turnover or claim of exemption reduction under the return file has to be first adjudicated by assessing officer in the assessment proceeding. Clause A of Section 1 of Section cannot be turned to an assessment, which in the present case the assessing was done. According to him, the petitioner could not have excluded the discount passed on the dealers from the taxable turnover, and to that extent, the assessee had declared turnover of the assessment. Even if assessing officer is correct in so accordingly, it is not under Section 25(1)(a) of the Act he can bring the turnover. Allowing him to do so would be only expanding the boundaries of the powers under Section 1 of the Act, but he cannot override the limitation provisions contained in the state chapter in the result so-and-so of the so-and-so. So the Tripura High Court has below that the limitation which is provided for in the chapter for the purpose of audit assessment as well as the turnover escaping assessment, one cannot go beyond to that. And because if the audit assessment is barred, the turnover, escapement of the turnover, the assessment is barred. One cannot say that the scrutiny of the returns is not barred, and after 15 years also, a person, the assessing officer, can initiate the proceeding for the scrutiny of the returns. So, in my humble submission on these two scores below, the action of the assessing authority is absolutely legal and without jurisdiction. Now, the last submission which I was making for Lordship was that the power under Section 39 of the Act had not been delegated by the Commissioner to the assessing authority. Your Lordship can see Section 26 of the Act below.
Section 26.
My lord.
Yes.
My lord, it says, subject to the such restrictions and conditions as may prescribe, the Commissioner may, by order in writing, delegate any of his powers under the Act to any person appointed to assist him under subsection 1 of section 25 of the Act. Notwithstanding anything contained in section 1, the Commissioner may transfer any of it is not appointment. So, my lord, 1, the Commissioner, by an order in writing, has to delegate his powers to any person appointed under section 1 of section 25 of the Act. Now, your Lordship may see. Rule 3, my lord. Rule 3, chapter 2.
1 second, I don't think we have the rules in front of us.
My lord, I think we can go to
Itu popcorn. Kenapa itu popcorn? Semanta. Blue Baba.
My lord, I quoted in my affidavit of opposition at page 10, my lord.
Who's the local counsel, Dr. Sarah?
Miss Rakhi,
You should given the list of books and the what you require, the rules, the act, whatever.
No, only one VAT Act and rules were there, so my lord, the.
No, I mean
you
didn't give a copy of the compilation of the rules.
That was there in the book. Well, if your lordship just looks into page 10 of my affidavit, my lord.
Of your affidavit?
Affidavit, no, reply.
My lord, rule is here if my lord.
Page 123 of this.
You don't have that book, they've taken it back upstairs.
My lord,
Yes.
Same.
See that those pages all wrong. Last time that's why this publisher, whoever, the way they've made it.
My lord, that's why I am also finding difficulty.
Very difficult because that book, I think, that blue one.
It's
the
wrongly.
covers,
Wrongly,
we sent
the
it.
pages are heavy.
All happened. Yes.
Sections are very much, my lord, here and there, my lord.
But the rule 3 only says there is Commissioner may delegate power by gazette
Mr.
publication.
Majika, hand over the book, my lord, Mr. Majika.
Yes.
If your lordship looks into my affidavit reply, my lord, page 10.
Rule 3.
The real.
Page 123 of the blue book.
1 second, page 10 of your reply. Yes. Rule 3, okay.
My lord, Rule 3 at page 10, my lord, if your lordship looks into, my lord.
Like a blind man looking around. Subject provisions of the Act and rules made thereunder, Commissioner.
My lord, my lord.
Yes.
Rules made therein,
Section
Commissioner may
26.
by notification in the official gazette delegate the powers to be exercised by different officers under subsection 1 of section 26 of the Act and shall by like notification specify the areas in which the powers are to be exercised by such class of persons.
Delegation.
My lord.
It comes from section 26 only. Rule
26 and the rules which could say in the
Rule 3, yes.
Rule 3 is there, my lord.
That's it. And 5?
Now, my lord, 5 if your lordship looks into, my lord. My lord,
You're talking,
The
you
power-
have to say 5 and 7 imposes restrictions on the delegation also. Does it have any
Delegation
relevancy?
powers.
Does it have any relevancy for the matters of this present case?
my lord, I spoke, my lord, only the 7 if your lordship looks into it, my lord. 7.
Yes.
While delegating the powers by the commissioner, he shall not delegate to any of the officer appointed to assist in any power other than those enumerated in the suspect section so and so. So this is a restriction, my lord, which has been put on the commissioner while delegating the powers.
Okay.
Now the charge which has been given, the table, to Rule 7, my lord.
Table.
Beyond, after Rule 7, my lord,
In the book, my lord.
Oh.
there is a table.
Here the table.
Has your lordship got it, my lord?
Yes.
My lord, this table is not delegation of the powers, because this table is for Rule 7. This says, my lord, that the powers should not be delegated to any officer appointed to assist in any power other than those enumerated below. So it says, my lord, that whatever has been enumerated below, beyond that the commissioner should not delegate. I think I am clear, my lord.
Yes, yes.
Now this table is not delegation of the powers.
It's just a directive.
My lord, this is only a restriction on the power of the commissioner while delegating the powers. If your lordship just take the table again, my lord, for the sake of repetition also, Rule 7, if your lordship looks into it.
No, we get it. Yes.
My lord.
He shall not,
So,
because it's already given with not clause. He shall not accept to these, this kind of thing.
My
For
lord,
limited
my
time.
lord.
Yes, we get it. Yes.
because if your lordship looks into section 26, 3, Rule 3, then it is only delegation by a commissioner by a way of notification which is published in the official gazette. Now 7 says that you cannot delegate the powers except whatever has been enumerated in the table below.
Mm.
Now a stand has been taken that this table is the delegation of the powers by the commissioner
Where has the stand been taken?
in the affirmative position. And secondly, my lord, if notification has been annexed in the second affidavit, if your lordship looks into it, in the second affidavit, page 4, my lord.
Nine 309.
Yes,
My lord, this is 9th, my lord.
7/3/2000.
Now this is about
7-3. What is
My
this?
lord. My lord, this is a order issued by the commissioner of taxes, which he addressed to the super taxes about scrutiny of the returns.
Yes.
Now it says, my lord, that in terms of section 1 of section so-and-so, Meghalaya so-and-so, each and every dealer in terms of so-and-so, that your lordship will look into, my lord, at page, second page, my lord.
This is complicating the issue.
Para-
In case a dealer
Yeah.
fails to furnish.
My lord, yes. If the dealer fails to fail, then the manner of completion of the provisional assessment laid down also, the prescribed activities should bear in mind also. This is an instruction given how to carry out section 39, power under section 39 of the Act. Now, without there being a delegation of the powers of Section 39 of the Act to the assessing authority, the instructions given how to carry out the powers of Section 39 of the Act has no meaning. The Commissioner can issue such instructions only when he has delegated the powers. This letter.
So your contention, no delegation was there, no valid delegation. Yes.
No valid delegation was there.
As per the rules, has ever happened. Yes. Okay.
My lord, and if no valid delegation is there, then the instructions, the reliance on such type of instructions has no value, because this cannot take effect as a delegation of the powers.
Okay.
So this is my submission on the first case, which is here, and after hearing the reply from the learned AG.
So yours is confined to 3 basic points. That prerequisite of Section 35 is absent in the Section 39 notice, or then there's no the limit. Second, with regard to limitation, reasonable limit should be 5 years, and your third is that there's been no valid delegation of powers. That's all. 3 points.
This third one I will submit before Lordship. The third one is only on the last submission before Lordship.
Is the last line of defense, you mean? Yes, we understand that. Yes.
Because this is some extreme, the submission. So I will not like that, because it will have a far-reaching effect on the other cases also, So that is only a last resort,
Last line of defense, yes. Mr. Khan, you can take your book back. It's good to see a lawyer who reads a book really well that's torn to pieces.
And this was the only.
Yes, my lord.
Yes.
May it please your lordship.
Yes.
Your lordship has seen Section 35.
Yes.
Kindly see Section 35 once again. Section 35(1).
Yes.
And marginal note also, your lordship may kindly take note of marginal note. Periodical return and payment of tax and interest. Your lordship has seen marginal note, left side, it is the periodical return and payment of tax and interest. Section 35.
There's no marginal note in this book.
You're
looking at Gazette notification.
I am having Gazette notification.
That's why you just putting out the deeper waters. Now we're looking at the same act in 3 different 4 avatar, 5 avatar. What will you do?
I'll place, my lord.
It's better you play the Gazette notification then. You're reading a marginal note. So
No,
because that will have. I'll place that also, my lord.
Okay, you kindly
see one.
Kindly continue.
See one, my lord.
Yes.
Yes, my lord. 1. Tax payable under this act shall be paid in the manner hereafter provided at such interval as may be prescribed.
Yeah.
So tax is required to be, this is the charging section. Right, my lord? Now 2, my lord, every registered dealer shall in the prescribed manner furnish such return by such date and such authority as may be prescribed. So there is a class of dealer who is registered. 35(2), my lord.
Yes.
So a registered dealer is required to furnish the return on his own in the manner it is prescribed.
Yes.
Now after 35(2)(3) comes, my lord.
Yes.
Any dealer, my lord, so it is a class of dealer who is not registered. Kindly mark this, any dealer other than a registered dealer. So 35(3) will apply to a dealer who is not registered. Any dealer other than registered dealer, my lord.
Yes.
Admitted case of the petitioner is that he is a registered dealer. I kindly see the synopsis.
Okay.
He is a registered dealer. So I don't know how this argument was being advanced that 35 3 will apply to my lord. In the synopsis only, just now I noticed, my lord, first line is there.
Yes.
So he is a registered dealer, my lord. Once he is a registered dealer, kindly come back to that. That is not a dispute. It is an admitted case. He is a registered dealer. So kindly come back to the section again 35, my lord.
Yes.
Now 35, my lord, says that any dealer other than registered, every registered dealer shall be in prescribed manner furnish the return. 35.2, your lordship, I am concerned with 35.2, not 3, my lord. Because he is a case, it is a case of petitioner being a registered dealer. Now, if there is a dealer, what happens after the returns are filed, my lord? 36, your lordship, kindly see 36.
Yes.
36, if a dealer required to file return under subsection 1 or subsection 2 of 35, my lord. So the 36 will come into operation, my lord, for a registered dealer. 36, my lord. Fail, if a dealer required to file return under subsection 1 or subsection 2 of section 35, A fails without sufficient cause to pay the amount of tax as per return for any tax period or furnish a revised return under 35(3) showing a higher amount of tax than the shown by him in the original return, or fails to furnish return, fails to pay taxes, etc. He fails to, my lord, all these requirements after this, 3, your lordship will see the every procedure is return default.
Yes, one second. We are again.
What I will do, my lord,
One second, Mr. Attorney General. Now this book is totally different, this 36.
Oh my God.
You've seen the book, Dr. Mozika, you look at the book, you have the same edition. 36, what is being read by the Advocate General and what's given the book is totally different.
This 36 is return default, my lord.
Return default, yes, but see what it says. Now it starts with if deal required to file. A, it fails of sufficient cause to pay the amount of tax as per the return. And the book says furnishes the revised return, section 3.
Age missing, my lord. I will do one thing, my lord. I will prepare a compilation of rules because I don't have rules as of now, my lord. I went through the act. I will prepare a compilation of the gadget which is there on the site, my lord, and rules also and relevant thing. I will place it because, my lord, your lordship will have to interpret
there's
the
a
act
footnote,
and
my
rule,
lord.
my lord, and
There's a
those have to be correct, my lord.
The footnote says as amended by 2005 Amendment Act, my lord. And it appears the learned age is referring to original gadget notification, my lord.
At least you give us the courtesy of at least giving a correct, what rules are applicable, what acts applicable.
Mr. Banta's book is the only book that's available.
No, we'll get it from the government, my lord. We'll get it all gadget notification, my lord, from the government also. Because if there is some problem in the publication, all correct rules.
At least
Because what I saw that
the one thing you can do is at least, if the amendments also are put together, and then, you can refer cross-reference to the amendments being made to any particular section. That's all in the note. That's fine. If suppose section 36 has been amended and a certain subsection has been deleted, that should reflect in, the note that is given to us. Or we'll be guilty of quoting a provision that's already been deleted.
Yes, I will also be guilty.
This entire book, all the pages says, my lord, as amended by Meghalaya Value-Added Amendment Act 2005. All the pages, most of the pages.
Then the Gazette rule it is amendments is the best way. We'll post it again on Tuesday or Thursday? Next Tuesday?
Thursday, posting Thursday.
Thursday, I think we have other matters already posted.
So after 10 days, we may have it.
We'll have it next
so that
Tuesday.
I can keep it.
1 week. We'll not adjourn it any further, yes. Yes, due to our business comments, arguments, however, due to what is the reason given? Due to there being no clarity with regard to the
rules and
just write list the matter for further hearing on that is next Tuesday. Then Archival Data to provide a compilation of the applicable acts and rules as amended up to date.
Yes.
Yes.
My lord, I take a liberty from your lordship, if on the next date, I may file a short written submission and give a copy.
No, we'll give you enough liberty. Don't worry. We'll conclude the submission. We'll conclude the hearing first. If we find a necessity, then yes.
My lord, thank you, lordship.
Yes.
Because the second case, again, the provisions will be different. So that argument will be different,
It's okay. Teachers, my court officers, court masters inform me that on next Tuesday it'll be a bit difficult because we have two divisions.
Let it be Thursday,
Next Thursday.
Well,
yes.
As you because convenient to your lordship,
This is 17th holiday. 17th holiday.
17th holiday. Well, 21st or 22nd.
21st or 22nd.
22nd.
Subject to convenience of your lordship and the delayed agent,
Because next Thursday we have two division benches running, and I have my own single bench matters. So I don't want to inconvenience the lawyers who wait till 1 o'clock to do hearings.
And as per the convenience of the court,
Yes. Yes.
I'm ready on
Item number 6.
Well, the appeal in this matter before the Apex Court is still pending, my lord. Slated for September, my lord.
Yes.
They've gone to Supreme Court, my lord.
Who has gone?
We have gone, my lord.
What is the matter and issue?
My lord, here, my lord, we are challenged one order, my lord. There was a cap fixed by the central government, my lord, beyond which, if the amount is beyond that particular cap, my lord, the department.
Oh yes, that same notification will not apply in this case also.
In this case, our case was, my lord, that the subject matter, my lord. My lord, here gold seized was more than 1 crore rupees, my lord. They say that the tax liability is less than 1 crore. But that contention was rejected. Our submission was upheld, my lord, by the Honorable Court. They've gone to Supreme Court against that. We are saying that the subject matter of dispute is more than 1 crore.
What is in dispute? What is
This is a gold season.
Gold season.
No. What is the main? Now what's pending before here? If it's gone to Supreme Court against
My
the part
lord,
of the order.
they submitted before the Honorable Court, my lord, because it is below the threshold limit, my lord. The department is barred from filing the appeal.
Yes.
So that contention was rejected, my lord. Against that order, they've gone to Supreme Court.
Rejected by us?
No. But on the Chief Justice.
Okay, at least after 3 weeks? After?
Now is fixed from September, my lord. Any date after that. September 23rd is the date.
Open to that, or you want to press with the matter? Yes, as the matter is.
It's true, my lord. If in that application is held otherwise, my lord.
Yes, then this matter will go.
It would go on.
Where is that? The Supreme Court, yes. Yes. Mr. S. Thapar submits that the matter which is pending before the Supreme Court is fixed on
23rd of September.
23rd of September for consideration. According to this matter thereafter. So await any outcome. Yes. Yeah. Sorry, had some urgent administrative work. Yes.
Any mention?
I beg. Item number 30, Your Lordship.
Can you please cut the sound?
I beg to mention item number 30, Your Lordship.
30.
Yes.
So, Stomoni coach.
Yes, Your Lordship.
Why? Who's the other side?
SD.
Who's the other side? Changrai Su. You informed them?
Yes, Your Lordship. I have informed the District Council.
Okay. 1 week, 2 weeks?
2 weeks, Your Lordship.
Okay, yes, next.
Obliged.
Make it quick. Yes. Yes.
May it please Your Lordship, I beg to mention item number 37 and pray for 2 weeks' time, Your Lordship, as the conducting council is having some personal difficulties.
Who's going to Mr. Gautam?
Yes.
Yes.
Lordship? Yes, no objections, Lordship.
Okay, 2 weeks, yes.
Your Lordship, similar prayer, Lordship, for item number 38.
Who's the other side? Mr. Shulai.
No objection, Your Lordship.
Okay, yes.
Much obliged.
Yes, yes.
Your Lordship, I beg to mention item number 34, Your Lordship.
Yes.
Your
Why
Lordship,
Mr. Gurung is avoiding this matter every time?
Your Lordship is having some personal difficulties, Your Lordship. Just 1 week.
No objection.
No objection, Lordship.
Yes, 2 weeks, yes.
Some instruction is required to be placed, we will place in that instruction.
After 2 weeks, okay. Yes.
Obliged, Your Lordship.
Yes, Mr. Demnath.
Item number 36, I am the pro forma respondent here.
Oh, pro forma, important, then you can't take adjournment. Where's the petitioner? Yes.
Lordship.
Ready with the matter?
Yes, Your Lordship.
Then why you want to take time?
Because
You
it is
pro forma.
addressed to me, but I didn't
Yes.
go through. I didn't go through properly.
Do you have anything to say, or you just a passenger in the case?
Your Lordship,
Your Lordship, may this matter be called.
I didn't go through properly. It is handed to me.
Then go. Let it be called. Then they are objecting. Yes. You can read the meanwhile.
Obliged, Your Lordship.
Yeah. Yes, yes.
Supplementary list item number 1.
I should mean this emotion.
Sorry. Daily list item number 1.
Daily list.
Daily list item number 1.
That's supplementary list.
This is a contempt matter, my lord. My lord, may I kindly come to page 31, my lord.
Yes.
The last paragraph, this order will be operated to reinstate the appellant in service. He is to be reinstated within 2 weeks of the punishment order in term of our order being made by the Deputy Inspector General of Police. So, my lord, then we have communicated in the next page, Annexure 3, my lord, page 33. And we have communicated on 30th 4/2025, my lord. But till
How
now,
much time is given?
6 weeks was given total, my lord. So we have served them we have informed them about this order on 30th 4/2025, my lord. So more than 6 weeks, my lord.
Yes. More than 6 weeks gone. Give them some more time.
Let notice go, my lord, to the
11/4/20. Yes. Heard Mr. SD the competition issue notice returnable in 2 weeks. Shall be taken by AD within 3 days. Yes.
Item number 2.
The election case was huh? Come check because of this. Let you in. What this would you check, yeah? Huh? Please, Delhi. Yes, Mr.
Please, Your Lordship. Your Lordship, here we are approaching this Honorable Court for direction for the respondents to supply us electricity connection, Your Lordship.
Electricity connection?
Yes, Your Lordship.
Why it been disconnected?
It has been disconnected, Your Lordship.
Line?
For commercial line, Your Lordship.
Commercial line.
Now
what reason have they refused?
The reason is that...
What reason have they disconnected rather?
It was disconnected since the year 2002, Your Lordship.
Disconnected?
Yes, Your Lordship. So they were citing there were dues, pending dues. So basically what happened, Your Lordship, the respondents had preferred a money suit for claiming of the dues, Your Lordship, which was dismissed on their default, Your Lordship. Subsequent to that also, Your Lordship, they had filed an application for vacating the dismissal order, and that application also was
Then what happened?
that was also dismissed on default, Your Lordship. So as
That was a default also.
yes, Your Lordship. Now since 2002, Your Lordship, there's no electricity connection in the premises.
No, what money suit is this? Connection to what?
The money suit is at Annexure 1, page 16, Your Lordship.
Okay, no, the connection to you are Mr. Simiti, sorry.
Yes, Your Lordship. Previously, it was for running a cement factory in the name of my father, Your Lordship. Now my father is also already deceased. Now the company also is already defunct, Your Lordship.
So the electricity dues still remain.
It's still
they filed a suit against
They filed a suit. The dues are still disputed.
The matter was taken forward.
Yes, it was contested. It was dismissed on default.
Where's order dismissal default?
It's on page 33, Annexure 3, Your Lordship.
So now, what do you want? Let's see your prayer. Reference statement. What representation is this? 15 and 24.
We have submitted a representation saying that there's no proceedings pending. So as
Yes, Mr. Pani, you have any instructions?
Lords, there are two electricity connections that are there with the petitioner, and one there are dues of about 75 lakhs, the other there are dues of about 6 lakhs. Presently, my lords, as far as I can see, that the representation is pending at page 13, and they have sought a direction from this court for disposal of the representation. Because we can dispose of the representation within a period of 2 weeks, my lords.
Okay. Where's your representation? You're asking for
representation.
Now you're saying that there was another concern which had not paid the bills, correct?
Yes, Your Lordship.
Against that, money suit is filed against you.
Money suit is filed.
That money suit is dismissed.
Yes, Your
default.
Lordship.
And now you're a different person asking for
A different person, Your Lordship.
Not the same.
Not the same.
Not a continuation of the
Not the
same
same.
entity.
This dues is with regards to a defunct company, Your Lordship. So
And is another commercial entity
yes, Your Lordship.
in the same premises.
Yes, Your Lordship.
Well, so as per my instructions, they are the same persons. Same property, if there are certain dues, the Electricity Act provides
What
that.
does the Act say? If the same property,
Then you have to clear the dues and then thereafter get a new connection. The judgment of the Supreme Court is also there on that issue.
will you be satisfied if they take up representation or you want? Yes.
Let them file a affidavit, Your Lordship. Because
File affidavit for what? If he's already saying that he's already conceded to your prayer number 1. See your prayer number 1. Where is that? The prayer number 1. See.
Page 13, bottom para 35(1).
Yes. Prayer number 1. Just now I've seen it. Yes.
I'll just take instructions, Your Lordship.
What instruction you will take?
Can Your Lordship kindly grant liberty if let them decide.
All liberty, see, prayer number 2 also declare the refusal to act upon a person's representation is illegal. They said they'll consider it now. We'll give them 6 weeks time.
Yes.
Take down. Third, Mr. So for the petitioner, Mr. S. Pandey, who's present, who accepted notice on behalf of all the respondents. The brief facts are that the petitioner.
I am representing respondent number 327.
Oh, sorry. 327. And
The accepted notice on behalf of respondents 1 and 2, Your Lordship.
your name?
Miss S.K.H. Nang.
Yes, so and so. The brief facts issue is that the petitioner is aggrieved, the petitioner, sorry, the writ petitioner is first court being aggrieved with the non-grant of a fresh electrical connection to her premises.
Yes, Your Lordship.
Yes, situated at, okay, if it was situated at, where's the premises?
Umbang Sumer Riboy District, Your Lordship.
Located Umbang Sumer Riboy District, stop. It has been submitted that in spite of a representation dated 15/11/2024, which is next year 8, the respondents have not given the same in consideration. Consideration. And as such, the writ petition's concern is without any. Has it have little connection now?
No electricity connection.
Without any electricity. Stop. Added to the above submission has also been submitted that the concern of the petitioner, present concern petitioner, is not the same.
It's not the same, Your Lordship.
As the earlier. Oh no, we'll not record that. We just let's dispose the representation enough. What are you thinking of facts? Oh, puli. The petitioner's concern is without electricity since the year
2002, Your Lordship.
In fact, it's written in the representation. It is 26/7/2022.
That was
26/7.
2000. That was a typographical mistake, Your Lordship.
Mr. Pasantio submits that at this stage it would suffice if the respondents number 3 to 7 are directed to dispose of said representation within a time frame. Yes. Mr. S. Pandey, next by appearing for the respondents at the outset, has submitted that the representation as preferred by the writ petitioner shall be taken into consideration. If praise for is allowed, how much time?
6 weeks, my lord.
6 weeks to consider and dispose of the matter. Stop. In consideration of these submissions made on counsel for the parties, this petition is being disposed with the direction that the representation dated 11/5/2024,
15 November.
Or 15/11/2024, which is annexed next year 8, be looked into disposal by the respondents within 6 weeks from the date of this order. Matter of instance disposed of.
Obliged.
Item number 3.
May it please Your Lordship. Your Lordship, this matter pertains to Dilmagri Akhang, Your Lordship.
There's a caveat. You've served
Yes, Your
copy.
Lordship. Yes, Your Lordship.
You've got a
Served
copy.
copy.
Just take down first caveat. Page number 80/2025 of this. Mr. P. Sama is present on behalf of the caveator, who has already been served a copy by the writ petitioner. Stop. The caveators have been arrayed as
5 and 6.
respondents. There's only 5. There's only 5 answers have been arrayed as 1, 5, and 6 in the minute petition. Upon this caveat stands discharge. Yes.
Your Lordship, this matter pertains to Dilmagri Akhang, Your Lordship. Your Lordship, the Dilmagri Akhang, Your Lordship.
Yes.
Your Lordship, the Dilmagri Akhang is an Ajiksia Akhang, Your Lordship.
It's
which is a Ajiksia Akhang, Your Lordship, which is a joint Nokmaship and is administered by the 2 Nokmas, Your Lordship. One from Ningminza clan and one from Bangsang clan, Your Lordship. Your Lordship, what has happened, Your Lordship, this Nokmaship matter, Your Lordship, has led to a series of litigation, Your Lordship, which has even travelled up to this Honourable High Court, Your Lordship. So, Your Lordship, there are 2 separate matters, Your Lordship, pending before the Deputy CM, which is the respondent number 3, Your Lordship. So your
With
lordship,
regard to one Nokma or both the Nokmas?
both the Nokmas, your lordship, but it's pertaining only to the same Akang, your
I
lordship, one
understand,
Akang, your lordship. So your lordship, what has happened, to avoid multiplicity of cases, your lordship, the petitioners has filed this application, your lordship, for clubbing both the matters, your lordship. But the respondent, before the respondent number 2, your lordship. But the respondent number 2 has passed an impugn order, your lordship, rejecting the application for clubbing or without giving any valid grounds, your lordship. So being aggrieved by that, the petitioners preferred an appeal, your lordship, before the respondent number 3, your lordship. Then, your lordship, the respondent number 3 also mechanically upheld the order of the respondent number 2, your lordship. So, your lordship, the petitioners are before this honourable court with a limited prayer, lordship, just for clubbing of the 2 matters, your lordship.
Only one question: are the records the same?
Yes, your lordship, it's the same, your lordship, pertaining to the same Akang, your lordship.
Like in the proceedings, are the records similar
Same,
or
your lordship.
same, or
Yes, your lordship.
or they have a bearing, or are they separate?
No, same, your lordship.
Because one's Mangsang clan, one's by.
Yes, your lordship.
One is by. You said it's a joint. It's
Yes,
a
joint
joint
Nokmaship, your
by
lordship.
two
One by
Nokmas, right?
Mangsang
But
clan.
they come from different lineages.
No, your lordship, the main thing is like it pertains to the same Akang, your lordship. The same Dilmagre Akang, one Akang, your lordship.
Yes.
So, because the court won't come to a contrary finding, your lordship, so we just want for the
But are
clubbing
the
of the
records
matters, your lordship.
common?
It's common, your lordship.
Is that a fact?
No, my lord.
If the records are common, then there's no reason why they should try differently. But if it's for 2 different Nokmas, I mean, this joint Nokmaship,
Yes, your lordship.
then if the claims are different for the Nokma 1 and Nokma for Nokma
Yes,
2,
your lordship.
then we can't take it together.
My lord, may kindly come to page 63, my lord. Para 6.
If the records are common, then
No, my lord, it's not common, my lord. According to our
he
understanding.
submitted as common.
No, my lord. My lord, may kindly see para 6 of page 63.
Yeah.
Since the nature of this case are completely distinct from each other, moreover, the issue in the first instant case is a Nokma dispute between the Ningmangja clan, my lord. There is a dispute within the clans, my lord. And in the second instant case issue is an Aking dispute between the 2 different clans. How it can be taken up, my lord? Then there will be three parties, my lord. There is a dispute within the Ningmangja clan, my lord. That means within the clan there is a dispute who will be the
Nokma.
Yes, my
and
lord.
the other one is between.
It's between like the petitioner and the respondent, my lord. How it can be clubbed together, my lord? The witness will not be same, my lord. The documents will not be same.
You file affidavit, yes. Yes, Mr. P. Sama.
I support this additional page.
It's not the same.
It's not the same.
Your dispute is regard with whom?
Another dispute is that page is very clearly that page 55, Your Lordship, because there's a different separate petition. Different this one. One is registered as 38 and 39.
No, fine, can be registered.
So this
But
is
if
completely separate.
so, one common judgment order will not suffice.
No, my lord.
Definitely.
Will not address the entire issue.
Yes.
Yes,
It can
One
address
issue
the
is-
Nokmaship dispute and this interclan dispute.
Yes. One is the Nokmaship. Who will be the Nokma from the clan?
It's an interclan.
Yes. Interclan.
And
And the one
clan
is.
who should be own the part. of it.
Yes, yes, my lord.
Another I like to draw your attention also page 55 kindly have a see. 55, that is a impugn order where they have filed a challenge. Here they have filed application for clapping together, but they themselves have not pursued the matter diligently. They have absent. It is written the order dated 30/07/2024, where it is clearly mentioned opposite present. That means opposite party. I am there. Opposite party. I have present. Lordship, that petitioner absent means they are the who come before this
However,
court.
they were
That is
represented,
the
your lordship.
conduct of that petitioner.
That is
Now, what stage is the proceedings?
Now, Lordship, that on 15, what I learned is they have even filed an application to appear before the EM.
No. What stage are proceedings?
No, on 15.
What stage are they in? Framing
They have to
issues,
appear on-
their hearing, their
Yes.
preliminary stage. What is it?
For appearance on
If for
15.
witnesses,
This
what is it for?
Appearance, Lordship, on 15.
Only for it's fresh, the appeal.
For all the
No, but said the final order refusing clubbing. That's over before the CEM.
Yes.
Now it's gone back to the EM.
Yes.
It has gone back to the EM. EM will decide both the
For
matters
appearance.
independently.
Yes, on 15, all the parties will appear. There is order. That's what I got instruction. So there is nothing in this case here. Separate matter.
No, the thing is that this order 28/5/25.
Yes, your lordship.
Yes, my lord.
Just place the order. You read it.
Even the
Let her hear. Before we jump into conclusions, page 62, you read it. Read the whole order, it's not so long.
The crux of the matter in the instant case is that the Nokmaship dispute GHDC so-and-so between the present appellants number 1 to 3 as petitioner versus Shri so-and-so had been duly registered by the Deputy CEM. In this case, the Honourable High Court remanded the case to the learned Deputy CM, IC Revenue, to examine Annexure 1 and 3 enclosed by the present appellants before High Court. The Honourable High Court in its remand order gave 10 months to complete the case. However, the present appellants filed petition before the Deputy CM on 27/9/2024 after 8 years of High Court order dated 1/12/2026. The Honourable High Court also in its previous order 25/9/2013 had allowed present respondent to continue as Nokma of Dalmagri Akang. This case is now at evidence stage. In another instance, the present appellant number 4 and 5, by claiming joint Nokmaship for Dalmagri Akang, had filed an Akang dispute case against the same respondent. This case also went up to the Honourable High Court, and the High Court, via its order dated 15/5/2023, had remanded the case to the Deputy CEM for fresh trial and the time limit for completion of the case in 6 months only. The case between the appellants number 4 and 5 as petitioner versus Shri so-and-so had been duly registered by the Deputy CM as GHDC RAV number 39 AC of 2023. Subsequently, issues had been framed and the case is at trial stage now. That in the meantime, the present appellant's petitioner in GHDC REV number 38 AC of 2023 and petitioners in GHDC REV number 39 AC of 2023 had combined together and filed a joint application before the same Deputy CEM for combined trial of these two cases by clubbing them together. However, the learned Deputy CEM, after hearing the parties, had rejected the prayer via its order dated 30/7/2024 on grounds that the nature of these cases are very different from each other, hence passed an order to proceed them separately only. Against this order of the Deputy CEM, present appellants filed an appeal in this court. Both parties got an amply chance to make out their own cases. I have also heard the counsels for both the parties. From their submissions and from the case records lying before the Deputy CEM, these two cases, GHDC REV number 38 AC of 2023, between the appellants number 1, 2, 3 as petitioners versus Shri so-and-so. Nature of the case is Nokmaship dispute case only since both parties belong to Ningminza clan only. While GHDC REV number 39 AC of 2023 between appellants number 4 and 5 as petitioner versus Shri so-and-so, nature of the case is Akang dispute between Ningminza clan and Mangsang clan. Since the nature of these cases are completely distinct from each other, moreover, the issue in the first instance case is a Nokmaship dispute with Ningminza clan, and in the second instance case issue is an Akang dispute between two different clans. In fact, these two cases had been going on separately for several years, and both cases went up to Honourable High Court. Accordingly, the Honourable High Court had taken note of these two distinct cases separately and given separate directions in the first instance. In the first instance, direction is for further examination of two documents only noted as Annexure 1 and 3 by present appellants 1 to 3 before the High Court. On the other hand, in the second instance case, direction is for a fresh trial to find out if Dalmagri Akang is a joint Akang of Ningminza clan and Mangsang clan or not. In absence of any leave from the Honourable High Court, which had remanded these cases before the Learned Revenue Court with specific time limit in both these cases and with specific direction for compliance. Moreover, the time limit allowed by the High Court in both these cases had been expired. In first instance case, the time limit is 10 months only, but now it is more than 8 years. And in the second instance case, the time limit is 6 months only, now it is more than 2 years. Hence, in absence any leave from the Honourable High Court to extend time limit.
I think we'll get in the day.
Your Lordship, there were litigations going on, Your Lordship. So, Lordship, at this juncture, I'm just praying for notice, Your Lordship.
What notice? We already heard the counsels. We've seen the order.
Let them file affidavit, Your Lordship.
I don't think it'll be necessary. Or you want Mr. AG Moment to be here?
Lordship.
We'll post again tomorrow. You get instructions. You tell them that the tentative view of the court is that the matter to go separately, because that's correct. It's between first one's a Nokma dispute between your client from the Mizang clan only, from one clan, and the other is with Mangsang. That's what this court saying in regard to the Aking. So it's two different things. It's not a question of Nokma dispute per se only.
It's yeah, this is a Lordship.
You take instruction. You list it tomorrow. Yes. for motion.
Hello, obliged.
You just give a tentative. You inform them that tentative court is not allowing it.
Yes.
Item number 4.
Hello.
Item number 4.
Yes, Mr. Hassan.
May I please, Your Lordship? Lordship, this item 4, 5, and in supplementary list item 1 and 2, these 4 matters are
4,
4, 5 here in main list, and 1 and 2, my lord, in supply are the same matter, my lord. Similar issue, my lord. My lord?
Meaning same matter?
My lord, yes, my lord, with regard to the fair price shop cancellation.
Oh,
my
that
lord.
fair price shop cancellation.
My lord, you will recollect, my lord, on
Yes, the
1st
last
of
week.
July, my lord. Yes, my lord. Since bench was not, I filed
Yes.
on, my lord.
When can come instructions? Have you heard them before cancelling where the control order? Is it as per the control orders? Have you?
Yes, my lord, I have annexed, my
My
lord.
lord, in fact, inquiry was conducted as far as
My lord, kindly
these
have
cases are concerned before cancellation of and they were given adequate opportunity, my lord, to be represented.
And in interim, what are you doing? You appoint other people?
My
How are
lord,
you managing?
I will require
Because
some instruction.
Because it concerns, it concerns the welfare and survival of these villagers.
My lord, kindly have page number 31, the control order 2022, my lord, section 13, under which the respondent number 3 has cancelled the license, my lord. Page 31 in my petition, my lord. Section 13, my lord. May I read, my lord?
Yes.
My lord. If any fair price shop owner or SK oil dealers, either by himself or through his agent or servant acting on his behalf, contravenes any of the provisions of this order or any of the terms and conditions of the appointment, then, without prejudice to any other action that may be taken against him, the authority issuing the license may, after giving him an opportunity of hearing and representing his case, suspend or cancel the license. A copy of the order suspending or cancelling the license shall also be furnished to the...
But they said you've been heard.
No, my lord. When complaint... My lord.
Yes.
My lord, when complaint was filed way back in the year 2023, my lord, in the month of November, and upon the my lord, news clipping, the respondent number 3 take cognizance and issue show cause notice.
When?
My lord, in the year 2024, my lord, in the month of March, my lord. The complaint filed by the labor union in the month of November 2023, my lord. Then thereafter, my lord, the respondent number 3, upon cognizance of the matter, the issue show cause notice to the petitioner, my lord, in the month of March 2024. Show cause was with regard to the allegation, my lord. Then inquiry was conducted, my lord. After inquiry, no report, nothing was given to the petitioner. No show cause notice, my lord. But as per section 13, he has to represent his case, my
your
lord.
Your case is that you were not given opportunity. After inquiry, you
no
don't know
opportunity.
anything.
No, my
you
lord.
know what happened?
My
on
lord,
one fine day to cancel.
My lord, yes, my lord, I come before you, my lord, my lord. On 19th
Yes,
June, my lord.
Yes, Mr. Sinkan, you get instructions of file affidavit.
My lord, in the meantime, my lord, I file a miss case. My lord, at least, my lord, third party right they will create, my lord. My lord, exactly, my lord, on the same.
Where's the prayer?
My lord, yes, I file a miss case, my lord.
Miss case is that the thing is that only that now that's why this court's asking who's running the show now.
My lord, no one is running, my lord. Only with regard.
Is that correct? I mean, these people are deprived of any.
My lord, there is temporary arrangement is already been made.
No, my lord, as per the 2022 order, my lord, the rules, my lord, in case of any suspension or cancellation, my lord, the monitoring committee constituted under the act, my lord, which is run by the chairman, will be the Gaumbura of the concerned place, my lord. The allotment was given to the said committee, my lord, but no license were issued, fresh license were issued, my lord. Fresh.
No, you're saying third party rights. Is there a question of someone, Mr. B, being put in your...
My lord, as per my instruction, my lord, the respondent number 3, my lord, kindly look at the manner in which the respondent number 3 is acting.
Manner. What we concerned first before we take up this matter for...
Yes, my lord.
Is that respondent, you've been cancelled. Now, no other person will be given your place, correct?
No, not yet, my lord. But as per the instruction I have received, my lord, the information from the subdivisional officer, my lord, the petitioner is contemplating the appointment of the fair price shop, my lord, the fair price shop, my lord. But since they have cancelled already, my lord.
Contemplating means
my lord,
appointing
there's
another person.
I might have by this weekend or maybe the next week,
that
my lord, they
correct?
will
That
appoint, my
is
lord.
only his verbal submission, my lord. There is no substance, my lord, as far as.
Sometimes you say verbal submission when you don't pass interim orders, and the next date
Now,
of
my lord,
when
may
it's
kindly
taken
see,
up
as
day
far
after
as
tomorrow,
these,
you come up with an order that we order appointed.
My
as far,
lord,
as
yes,
far
my
as these
lord.
cases are concerned, my lord, there was allegations, complaint was filed against
May
them.
2023.
Yes.
You took action till 25.
And thereafter, my lord, they were given so cause notice. They have replied to the so cause notice. Thereafter, my lord, this action follows regarding
That means
cancellation.
they have admitted.
Adequate opportunity was given, my lord.
No, my lord. No, my lord.
Adequate opportunity was given, my lord.
My lord, the petitioner herein was cancelled, my lord, after filing.
Take down, yes. Well, Mr. S.K. Hassan, learned counsel for the petitioner, issue notice. Mr. Advocate General, appearing. Oh, he disappeared. Is he appearing in the matters?
Here, my lord, yes, I was there in the initially, my lord. I have shown, my lord, that the allegations against them, my lord, that they have admitted there are two misappropriation by them, my lord. So, my lord, kindly give 1 week time. We will file affidavit, and then your lordship immediately matter finally.
S.K. Hassan, learned counsel for issue notice. Learned Advocate General, together with Ms. N. Sankon and M.S. R. Kolni and Ms. Ranja appearing all the connected, appearing in all the connected matters. Stop. It is submitted that the license fair price, what's it called? It's called the
Fair price shop license, my lord. PDS.
PDS license of the petitioner has been is submitted that the petitioner has been cancelled by order dated.
My lord, 24 June, my lord.
24/6/2025.
My lord.
Without the petitioner being afforded any opportunity of hearing.
Yes, my
lord. It is further submitted by Mr. S. by Night Counsel petitioner that on a certain complaint which had surfaced in 2023, an inquiry had been instituted, and on the basis of the inquiry for which the report was never furnished.
Never furnished.
To the petitioner, the impugn action has been taken by the respondent. Stop. He therefore prays that appropriate orders be passed, and has further prays that appropriate orders, and that in interim no third party interests be created.
My lord.
Stop. Mr. Learned Advocate General, on behalf of the respondents, submitted that adequate opportunity had been afforded to the petitioner, inasmuch as a show cause notice was also issued in the course of inquiry, and by due process, on finding the allegations to be substantiated, had cancelled the PDS license of the petitioner. He, however, prays that he may be given 1 week's time to obtain further instructions in the matter. For learned counsels for the parties, it is noted that the main grievance is based on the main grievance of the petitioner is, or the reliance has been placed by the petitioner on that rules, that is regulation.
My lord, regulation control order, my lord. My lord, Meghalaya Food Grains, Meghalaya Food Grains SK Oil Public Distribution System Control Order 2020.
Yes, main reliance has been raised by the petitioner on the Meghalaya Food Grains SK Oil, all capital bracket, open bracket, Public Distribution System, close bracket, Control Order 2022, wherein Section 13 has prescribed the detailed procedure for finalization. What for? 13, where 13?
My lord, page 31, my lord. Section 13. Suspension or cancellation.
Where, at order they call it orders, or they call it?
Section, my lord.
Okay, Section 31 has provided the procedure for suspension or cancellation of license, which the petitioner says has been violated.
21 of the Act, my lord, it provides
as
for
the
appeal.
matter is to come up for the consideration. Yes, for this is matter after 2 weeks for instructions or affidavit stuff. In the meantime, made clear that no third party interest shall be created, and that the food grain distribution shall be done by the respondents by ensuring that no citizens deprived
My
of
lord.
their due rations.
Ration, my lord. Food grains, my lord.
Yes.
My lord, all four matters are
Okay,
connected.
4 matters, same order.
My lord. Highly obliged.
Same, I'm taking your word for it.
My lord, same, my lord, same, my lord. My lord, with other two, my lord. Dates are different, my lord, in other two matters. In those two matters, 17 June, my lord,
They'll check it up.
my lord. And in those two matters, inquiry
And my
report
lord-
were not supplied, my lord.
My lord, we have already passed the order whereby alternative vigilance committee is distributing
Oh,
the
that's
food
fine.
grains,
That's
Lord,
fine.
by
Yes,
order
we
dated
said
is
that
matter
we're
of
not, we're not passing any directions on that, any observations.
Yes,
We'll carry on. Only that you come up how they're challenging only the due process.
My lord, yes, my lord.
Yes, my lord. Yes, my lord. Yes, my lord.
Supplementary
Highly
is
obliged.
item number 3.
Yes.
Please, Your Lordship. Your Lordship, this matter pertains to the suspension of a Sardar in a village called Brithangma, which is under the Noble Sophos ship. Lordship, my main aggrieved, I am highly aggrieved by the impugn order dated 7/6/2025, whereupon I was suspended without.
But Mr. Aim, you're not with this council party. You file a political appeal.
Lordship?
Have you filed a political appeal before the?
No, Your Lordship, I have not filed. Your Lordship, yes, I am aware that we have to appeal to the district council, Your Lordship, but
it's premature.
yes, Your Lordship. But what I'm asking for in this petition, Your Lordship, is just for a stay of the order of suspension, Your
You
Lordship.
cannot do that because the thing that you go to the district council, you take a call. Otherwise, we won't entertain.
I'll seek instructions, Lordship.
Yes, the council is allowed to obtain instructions in as much as
1 week, Lordship.
alternate remedies available before the set up committee of the KGDC. This is for 1 week. You tell them. Yes.
Item number 4.
Highly obliged.
Please, Your Lordship. Your Lordship, on the last occasion.
Yes.
Your Lordship, on the last occasion, we had filed a miss case, and it had been
Regarding the
closed.
effect of the
Implement
ex parte order, Your
ex parte
Lordship.
order. There was an ex parte order passed on the 19th of
19th
May
2025.
2025,
Yes.
where against parties respondent number 6 and 7. Your Lordship, on the last occasion, we had filed a miss case application, but it was closed on the grounds of defect. Your Lordship, with liberty to file afresh, which has been done, Your Lordship.
Yes. Your MS?
T. Potlong.
MS T. Potlong. Yes, you know objection.
No objection, Your
Yes,
Lordship.
I heard MS T. Potlong, then counsel for the applicant, who praised that who praised for recall of the order dated 19/5/2025, whereby the matter has been directed to proceed ex parte against respondents next 6 and 7 of heard also MSS M. Rahman for the opposite parties. If the court has perused the application on being satisfied, the order dated 19/5/2025 is hereby recalled, and the respondents number
6 and 7. 6 and 7.
6 and 7 are permitted to file the affidavit. You have not filed the affidavit.
We are yet to file, Your Lordship.
Yes. Permitted to take part in the proceeding. Stop. Stop in the main case. How much time you pray for?
3 weeks, Your Lordship.
In view of the order dated so and so and so, the respondents number 67 are allowed 3 weeks time to file affidavits. Just thereafter and so and so. In this case, not disposed. Yes.
Daily list item number 6.
Please, Your Lordship. Your Lordship, I pray for 3 weeks time due to.
Where's MSP Barasaji?
She has some personal difficulties, Your Lordship.
You have not filed affidavit till now?
No, Lordship.
When was the matter filed? Since last year.
Last year,
24.
Your Lordship, 2024.
Now in July. What's happened? She's sick.
She is, yes.
Yes, sir. You noted that the affidavit from her response yet to be filed. However, in the interest of justice, as prayed, 2 weeks for the times allowed.
7.
Lordship, item number 7 and 8 are both connected, Lordship.
Ready for hearing?
Lordship, respondents in item number 8, Lordship, were supposed to file the affidavit, Lordship. Respondent number 6.
No, 1 second. This is item number
7.
My lord, item number 7 is
the
the
contempt, Lordship.
My lord, but in this case, no notice has been issued, sir.
Okay. Call 8.
8.
This matter is pending division bench also.
Lordship, appeal has been preferred by the managing committee and private respondent.
Two appeals.
Matter, you have just making it linger.
There are 2 appeals, in fact, my lord.
And for this point number 6, I'm filing my affidavit in the court.
Ms. M.U. Ahmed, Learned Counsel for point number 6, submits that the as we file the court. What about number 7?
7 I've already filed.
Yes, all complete. That means.
Lordship.
Yes. You want to file a joinder?
Lordship, we'll seek instructions.
Just after 2 weeks for a joinder of this three. One time list lang same day. This also.
To number
Obliged,
9.
my lord.
I obtained status of service.
Lordship, I have filed a
They've been
status
served.
report. Yes, Lordship. And duly received also, Lordship.
Yes, an affidavit indicating service on behalf of respondents on respondent 5 and 7 has been filed of such notice complete all the parties. 5 and 7 even
5
appearing
and
today. Yes, you're appearing 5 and 7. When will he serve? When will he serve?
11/4/2025, Lordship. It was delivered. Page 6 of the affidavit, Lordship.
5 and 7. 5 regional director.
Yes.
Oh, you have a problem. The joint venture does it still exist?
I'm not aware, Your
Number
Lordship.
5. And 7 year, 5 and 7. 7 year appearing, then National Highway Authority of India. Who's appearing for National Highway Authority? Yes.
Nobody has appeared, Your Lordship.
No, I mean, Dr. Muzikal appear, I suppose. NHI who appears in this court? In like matters for this court, who appears for NHI?
I'm not aware, Lordship.
No one appears.
I'm not aware, Your Lordship.
Yes.
Your Lordship, there was one matter where Miss P. Bhattacharjee had been appearing, Your Lordship, in the other court, but
That is one. You file affidavits.
yes, Your Lordship, we filed.
We list it after 1 week for appearances. You inform the council. Yes, list after 2 weeks. Yes, to enable appearance of the response 5 and 7.
Obliged, Lordship.
Obliged, Your Lordship.
Item number 10.
I have taken step to the newly implemented respondents, Lordship, on 19/6, Lordship. So service report is awaited, Lordship.
Mr. S. Sheikh submits that steps have been taken on a newly implemented 6, 7, and 8. He prays that he took it on
19/6, Lordship.
on 19/6 and he stopped. Make my list after 2 weeks for further service report.
Master.
11.
May it please Your Lordship to kindly grant us 2 weeks' time to file a joint affidavit.
Who's the lead counsel here?
Mr. A.
How many times you taken for rejoinder?
This is the second time, Your Lordship.
Yes, what's your name?
P. Dolai. Miss P. Dolai.
Yes, record the name. Yes, so place was allowed for a 2 week time to file rejoinder. Yes.
Much obliged,
Much
Lordship.
obliged.
Well,
Please, Your Lordship. Lord, we will be filing the rejoinder affidavit
File rejoinder.
in the course of the day.
Yes,
This
it's,
matter may be posted for hearing also, my Lord. Proceedings will be completed after filing of the.
I believe the rejoinder is in response to a stated affidavit.
They have already responded.
3 to 12, my lord.
What about to the union's affidavit?
Unions will be filing today. We have already served a copy
Your
of
state affidavit? You won't
State-
file.
my instruction, my Lord. We have already filed.
You only filed rejoinder. Let us check. No. It's only been filed by 1, 2, 3 to 12.
Yes, my lord.
No rejoinder.
No, my lord. They have not given any response to our affidavit. There's no affidavit in response.
Sorry, my Lord.
So both of the deal file both rejoinders.
No, only for 1 and 2. And may be allowed time, my Lord.
Submits that rejoinder to the affidavit filed by respond 1 and 2.
1 and 2.
Will be filed in the course of the day. It also pays a further 2 weeks time to file rejoinder to the affidavit filed by 3 to 12 if necessary.
My Lord. Obliged.
13.
Lordship, this is that arbitration application, Lordship, where the respondents were supposed to file affidavit, Lordship.
We've not received instructions, Lordship. I'm praying for
How
some
much
more
longer?
time. 2 weeks' time, Lordship.
This 11.4, 11.5 application?
Lordship.
Yes, MSS for example, please funds allowed for 2 weeks time affidavit. Just that after and so on.
14.
Please, please, Your Lordship.
Yes.
Lordship, we have filed the so-called law in the contempt matter. And if your Lordship will see my reply, no contempt is made out, Lord.
Have you got a
Because-
copy?
I received a copy, Your
Just
Lordship.
now?
I received.
Have it after
No,
1
we
week?
not have to give.
After 1
Yes,
Yes, a show cause on behalf of the response has been filed. So we'll call this matter for 1 week for consideration.
Yes, Your Lordship. Much obliged.
15.
Please, Lordship, I humbly pray your Lordship to grant some further time to file my rejoinder, your Lordship.
How many times
This
did
is
you
the
do
second time, Lordship.
No,
Second time?
Your Lordship, this is the fourth.
The 4th time?
One time, I think it's second time.
Very confidently you're saying the second time. You pay cost. We'll allow you to
Lordship.
pay favorite cost.
Not fourth time.
And for saying something
Last chance,
incorrect,
Lordship, actually,
if somebody is incorrect, that means another 500. No, no.
I'm sorry, your Lordship, because it's not written here. Only further time is given here. So,
So you pay cost.
no, the next time I'll file it, Lordship.
Yes, though it is though this is the fourth time, the fourth occasion that the petitioner is seeking time to file the rejoinder. It's very important, not very.
Positively, I file because there's something I
It's
think
very
is very,
important.
very important because I feel very important.
And the court, this court is not inclined for understand. This court is inclined to grant you further time for rejoinder as three earlier
Yes.
policies have already been granted. Stop. How Mr. P.T. Sharma praised that the petitioner be allowed for rejoinder as it is of extreme importance.
Yes.
The prayers allowed, however, subject to payment of rupees 500 cost.
Failing. Next time you I fail, Lordship.
Next time you pay from your pocket this time for yes, 500 cost to be made over to the legal service authority for legal aid. Yes.
Yes, sir.
You file it first, then you pay first, then you file it.
Lordship.
16.
Much obliged, Lordship.
List up to 3 weeks. Yes.
Please, your Lordship. Lordship, this matter pertains to that to the service of one of the petitioner, whereupon he was terminated from service. So, in the interim, Lordship, Lordship has stayed the order of termination. So, the the union and the state are supposed to file any objections if they have.
Now
Lordship,
you're back in service now?
Under the process, Lordship.
My lord, in terms of the last order, my lord.
What do you want today?
Lordship, because the prayer which I am seeking for is the.
Proposal for hearing then?
Yes, Your Lordship.
Yes, if all affairs on board. All affairs are on board or union no?
It depends.
We do not have anything, my lord, to file because we have
objections to place them.
She was here just now. Yes. 1 and 2. You file affidavit or not? Yes, Mr. LCM submits that in pursuant to the order dated 9/6/2025, the process for reinstatement of the petitioner is underway.
Yes, Your Lordship.
It is noted that the affidavit you filed, Mr. Singhan?
My lord,
no affidavits have been filed.
Yet to be filed by the respondent. Accordingly, list after 2 weeks for affidavits is.
Highly obliged.
17.
My lord, 17 to 20 are connected matters. We are yet to file affidavit, my lord. On the last occasion, my lord, we have paid time on the ground that we required clarification on the instruction received, my lord.
Fourth
we have
time
received,
they have
my
taken.
lord. So we will be filing our affidavit, my lord. Your lordship, kindly give me 2 weeks time, my lord. Affidavit will be on board, my lord.
Yes, MS R20 submits that these clarifications have been received and the affidavit will positively be.
My lord, in 2 weeks
filed
time.
In 2 weeks, yes.
70 to 80, my
Yes,
lord.
after 2 weeks, yes.
Obliged.
21.
Here, Lordship, there's a miscase, Lordship, filed with regards to the tender, Lordship. Now, respondents were supposed to come with instructions.
If I submit, my lord, main matter was regarding the tender terms and conditions, my lord, technical bids, etc. He was disqualified in the technical bid, my lord. Thereafter, we filed the counter affidavit. No rejoinder affidavit was filed, my lord. Now, this case has been filed after everything is over, my lord, regarding the opening of financial bid, my lord. So, the miss case has nothing to do with the main matter, my lord.
But it has, my lord, because
No, one thing, if I remember correctly, last time financial bid's been opened.
Instructions
Yes,
were to
my
that
lord.
effect,
The
Lordship.
financial bids have been opened. Financial bids have been opened, my lord.
But last order is this miscase was it has also been submitted. The financial bids have been scheduled to be opened. Now, yes, they've been opened financial bids.
Financial bids have been opened, my lord. Financial bids have been opened.
The financial bids have been opened also since.
Those may have been, but the fact of the matter remains, well, as there's a single qualifying tender.
Those people come with instructions.
They'll have to come up with very cogent grounds, well, as to why they would want to proceed with a single tender.
No, let them.
It's not a
They
single bid,
they
my
want
lord.
1 week time to file affidavit.
Yes, my lord, we'll file affidavit, my lord.
Yes, whether
To
you
the
can go
miscellaneous
ahead.
case,
Yes.
but they have not filed
To
rejoinder
the
my
miscase,
counter affidavit, my lord.
yes. Yes. No, let them be.
They have to file the rejoinder to the main
General
matter
Praise Funds allowed a week's time to file a short affidavit to the prayer made in MC WPC 149/2025. Yes. Just after
In the
1 week.
meantime, my lord, they should file rejoinder also. They have taken so many dates.
Well, as now the entire
And in
facet
the
of that
main
matter
case-
has
in the main
changed.
case, Mr.
So they have to
Paul
file a
Praise
fresh
allowed
Well,
1 week's time to file rejoinder. You file a rejoinder.
No, my prayer is coming from the Advocate General, my lords. I will.
22.
Well, it's one small prayer I had. My lords have granted them a week's time, as my learned friend has submitted, my lords, that the financial bids have also been opened. Well, they should not do anything till your lordships hear the matter in a week's time.
My lord, it's a hospital matter. It's an
See, the
essential
thing-
supply. Your lordship has rejected their earlier order also. They made
That's on
similar prayer
concentration.
also, earlier
But,
also.
but how will they proceed one tender also? We let them come.
No, they are two tenders.
My lords, what would happen is,
Great contract. It's a case
in a
of
week's
great
time,
contract.
in a week's time, my lords, by the time the affidavit comes, my lords, they would not only say financial bids have opened, some contract has been signed.
Them as a party.
That's my only worry, my lords. Your lordships are considering is they have sought time for a week's time, my lords, to file an affidavit.
See, one thing, Mr. Paul, is that we don't want any disruption. It's the matter regarding medical supplies.
My lords, it's not a medical supply for an existing hospital. It's for a new college.
And in
For a new
case of-
My lords, I don't want even to get into those details because,
For
my
a new
lords,
college.
it's a new medical college is coming up So for 5 years, my lords, the course is for 5 years.
Yes.
Supply to hospitals.
Which all hospitals?
It can't. I'll just take your lordships to the
all hospitals or only the new proposed medical
No,
college?
no, my lord, hospitals, all hospitals,
Yes.
my lord, supplied. If your lordship will see the, I'll take your lordship to the main matter. What is the prayer, my lord, which your lordship has already rejected and filed detailed counter for it.
Well, let's kindly come to page 20.
Of the writ petition?
My lords, that's the tender. We are arguing on the tender.
Yes.
Well, it's clause 1. Cost of tender. Below that, my lords, name of work. My lords, may kindly have a look at name of work. Page 20, my lords, have it.
Yes.
Cost of tender, my lord, cost of tender documents. Below that is name of work. For supply, installation and commissioning of medical equipments for MMDSL Meghalaya.
What's MMDSL?
My lords, is that the corporation under which? The corporation which, my lords.
Okay. 1 week you file. No orders.
Yes, my lord.
Well, it's only my only prayer is.
No, if it's for medical
This
equipment,
prayer has
sorry.
already been rejected
No,
so many times.
I am.
You can correct it later.
22.
My lords, my lords, may I then just pray? Your lordships are not passing any interim orders, my lords. I quite bow down. My lords may only say that any action taken by them will be subject matter of the outcome of this
They are
petition.
misusing these lines in my lord all the time, my lord.
No. Where is the question of misusing?
They have no case, my lord.
In
They have
either,
no case at all, my lord.
my lords, if I am for the respondent, even I will say I have no. The petitioner has no case. What I am simply saying, my lords, that since your lordships are seized of the matter, it should not become that the matter should become infructuous, my lords, by some action of them that taking time, my lords, and then coming before your lordship saying that some orders
File
may
a
pass.
possibly 1 week. 1 week, nothing will happen. Yes.
My lords, on that understanding, my lords, whether it should not come back before your lordships with an order that we've already issued an order in favor of third party.
Go on, my lord. If anything is amiss, your lordship.
My lords, may I then just pray? May I then just pray that no third party right should be created in the meantime?
My lord, he is asking for.
Because then the next question is going to come, my lords, then I have to arrest somebody else as a party.
He is asking for interim leave
After
by
1 week,
backhand, my lord.
after 1 week. Since it's been prayer earlier on in medical, we don't want to cloud the issue.
Grateful, my lord. Grateful, my lord.
Obliged.
Let's ask him now. Orders?
Orders are likely.
Yes. Where's the rejoinder?
Your lordship, I need some more time to file the rejoinder for to the.
The matter is nothing is left for consideration.
Yes, actually,
No, lordship.
everything is the ritual has already been conducted.
Lordship, here the issue is like the petition. They want the court to decide, your lordship, whether the ministries, whether they are holding, they are eligible or not to holding the post and perform the rituals, your lordships. So you want some petition. So you want
Then
some
file
petition.
agenda, yes.
I'll file my rejoinder in the meantime. And your lordship, respondent 3 also yet to file their reply.
Who's number 3?
Hasn't been filed. Okay.
As per
Then
the
I
order
need
of
time.
this court, only respondent number 4 and 8 will be.
Yes, MS Panjom, please for a 2 weeks time for agenda. File, we'll close the matter after that.
Lordship, in 3 weeks time will be given.
Why 3 weeks time?
So, lordship, I'll prepare both at the same time, so we need some time.
It is able?
I have to prepare both at the same time, so I need some more time.
2 weeks time, I think we want the matter to be closed.
Okay, highly obliged.
Yes, sir. He has to appear both, so 1.5 weeks, so 1 rejoinder.
23.
Lordship, in this matter, I got the instruction this already is taken up the matter and.
Who's taking up the matter? Defense accounts, Allahabad?
It is sent to the defense accounts. This is the letters.
What instructions do you have? Let's see. You finish the process within 3 weeks. Is that all right?
Your Lordship, time framing we cannot say, Your
Why?
Lordship, because PDF go out with this Allahabad, they are the person to the
Why not?
analyze.
You are representing them also.
So all the process been over, so they'll be issuing the
24.
My lord,
1 second. You've given a copy of documents you've produced.
no, Your Lordship, just only copy I got. Only I don't have the copy, just my copy I given.
You have made photocopy also.
No,
Suppose the court retains the copies, what do you do?
because this letter addressed to me, so that's why. Your Lordship.
Addressed to you. Yes. Yes, what do you want to say?
my lord, my only humble submission is that since the petitioner herein is disabled, my lord, and for the fact that my lord also in the last order had directed the respondents to pay, my lord, so I only pray that it may fix a fixed time, my lord, so that they may disperse the pensionary benefits towards the petitioner, my lord.
Your Lordship already has taken the matters, and then it will, there is nothing to reject.
Yes, see, the last one for 26 March, you say early, you will dispose of early action since it is highly solicited. Then acknowledge receipt. Next letter is that family pension in respect of Om Prakash Tiwari so and so. Family pension clear pay above name is forwarded herewith as the same erroneously received in this office for want of stamp.
This was the mistake, Your Lordship. This has been corrected. This has been corrected and sent again.
Yes, Mr. R. Devnath, the CGC today has produced some communications indicating the fact that the pension of he's not a petitioner, he's a petitioner through petitioner, who's represented
Through his
by,
legal guardian, my lord.
through a legal guardian is under process stopped. It's noted from the documents that the same is pending before senior accounts officer.
From senior accounts officer already gone. It is only the controller defense.
That the it is submitted, not stopped. It was submitted by the little CGC that the matter is
with the controller defense
the
account.
final stage and it's pending before the controller.
Defense account. Allahabad.
Controller of
defense account, Allahabad.
Defense accounts where?
Allahabad.
Allahabad. Considering the fact that the same has been unduly delayed and the relief is with regard to a person who is disabled, it's expected that the entire process be completed within a period of 6 weeks from the date of this order. Copy of this order be made over to the learned CGC for auto transmission. Yes.
My lord, 3 weeks if possible.
6 weeks, you won't finish by the time Mr. Devnath sends, you send by email also. Yeah, take this back. Yes, after 6 weeks, yes.
Highly obliged, my lord.
I know you.
Yes.
24.
May it please your lordship.
The suspension order is beyond 90 days. There's no review or no modification.
Your lordship, I'm praying for 2 weeks' time to file affidavit.
Where's Mr. Sen? Last time he was not here also.
Yes,
Lordship, he's not appearing.
Why? He's avoiding.
No, your lordship.
We don't know. Maybe. Lordship, my limited prayer is that I should be reinstated back.
We listed today is Wednesday or Tuesday?
Tuesday.
Listed on Thursday. Assistant to the SN Learned Standing Counsel Nehu are available list the matter on Thursday for further orders. Yes.
5.
This matter pertains to because the petitioner is involved in printing the trading license card, Lordship. My agreement has been cancelled.
You got an interim
There's a
order.
stay order, Lordship.
Lordship, actually, as per the policy decision of the executive committee, since the month of March, they have decided to.
Then have you communicated that to him?
Yes, yes.
There's no communication.
We'll file affidavit, Your Lordship.
An agreement is for 5 years, Your Lordship.
No, let them. Otherwise, you
Let
have
them
to
file
go
the
on-
affidavit,
If
Lordship.
there's an agreement, then there's a contractual dispute. Then you go to commercial court.
Yes,
Lordship, but the decision there's no whisper on that.
Mr. Harsar, who's appearing with present behalf, the response for how much time?
1 week.
1 week time for the affidavit. Is that after interim order, if any shall continue the next day?
Lordship, the difficulty is that they are not allowing us to function, Your Lordship.
Not function,
To
they're not
perform
doing
that
any
duties.
work, that means.
Because, Lordship, they are not allowing us to do that, despite there's a stay order from this court.
I mean, no, they are not.
Because they're supposed to send the details and
for thing to print.
To print for printing.
But they're not sending it. We can't help that. I mean,
But there's a stay
your
order from this
agreement
court,
has been- It's been put on. Let them file affidavit.
1 week.
26.
One week.
Obliged.
Lordship, on the last occasion, Lordship, my client was asked to obtain
My lord,
the
we'll
instruction.
dispose
Lordship.
of his representation, my lord.
My lord.
Some time may be given to us, my lord. It is on page 56.
Page 56.
In fact, ASO was directed by the deputy CEM.
But he has not done anything.
He has not taken, my lord. I have taken the
He's
instruction.
not got any fuel for his car, that's why. He was-
Despite there is
So I have received the instruction from the deputy CEM, my lord. He said, my lord, we will do it. A bit of time may be given to us, my lord. We'll
No. This
We'll
will
demarcate.
because there's no fuel. You have no fuel, how the car will start?
My lord knows the practical.
Yes.
True, my lord.
These things always can't. What to say? Take down.
Bankrupt district council money.
As recorded by in order 37/2025, with S.E. Sheikh, Learned Counsel for the petitioner had submitted that the issue is limited only to the prayer for demarcation of land, which had been made over the before respondents 1 to 4. Stop. Next one, Mr. S.D. Learned Counsel for the respondents. Where is that? Where you refer to?
My lord, page 56,
Yes.
Annexure 5, my lord.
Yes.
That is the representation, Lordship.
Direction may be given to respond number 3, my lord. He will do it, my lord.
Yes, sir. Mr. Day, S. Dealer, Counsel for the page 56.
Page 56, my lord. A type copy is on page 58, my lord.
There's representation.
Yes, Lordship.
In fact, we have already given a direction to the ASO.
Where the direction?
My lord, in the top, my lord, the deputy CEM on 6/5/2024.
Yes, Mr. S. D. Learned Counsel for the respondent has submitted that on the representation made by the petitioner on 6/5/2024 on the same day itself, ASO bracket resettlement had been directed to do the needful at an early date. He submits that representation of the petitioner had since been addressed, but only that the respondent number 3, has assistant settlements was not carried out the task. So he submits that the matter can be, he prays the matter can be disposed of by issuing appropriate direction to respondent number 3. Stop in consideration submissions made by Mr. Isley. So this petitions close with the direction that the respondent number 3 assistant settlement officer as directed by the deputy CM shall complete the demarcation within a period of
Time frame, my lord.
of
At
6
least.
weeks.
My lord, 45 days.
We'll
do it.
45 days from today.
Yes.
Matter stands closed and disposed of.
Hello.
Highly ordered.
I'm not getting hearing. Poonam?
No, no.
Hearings will do after at 2:15. Matushra, you some difficulty?
Lordship, if I
like the way all the lawyers gravitate when they say take hearing at 2:15, as if
36, Your Lordship, if on 10 or 16, Your Lordship. 10 or 16.
36.
Your Lordship, yes. Either on 10 or 16, Your Lordship.
Ms. Ibla has objections.
Yes, Your Lordship.
She wants to hear it.
Then let it be on 10, Your Lordship.
Where's the pro forma gone?
He was here.
Mr. P.T. Sama? No. Mr. Debnant? What's the matter about?
Lordship, this with regard to the where the petitioner has been reverted back to the state pay.
Where's you're arguing the matter?
No, Your Lordship,
Then where is he when the other matters are called out?
He's coming, Your Lordship.
We'll have it next week after 1 week. Yes.
Obliged.
He should be here at least if he's ready with the matter. Yes, that's it.
Obliged, Your Lordship.
Please, Your Lordship. Item 27 and 28, Your Lordship. The connected matters. Can you have it after?
You wanted to have it 2:15?
Yes. After 2 weeks, Your Lordship.
No objection, Your Lordship.
Yes? No objection?
No objection, Your Lordship.
At least show some enthusiasm.
2 weeks, Your Lordship.
2 weeks, yes.
Obliged, Your Lordship.
29.
29.
We'll do 29.
After 2 weeks, Lordship.
Lordship, we are ready, Lordship, otherwise, because it was only limited to that action whether contempt will lie or not. Because
1 week, we'll finish this matter. We can't leave it pending.
And item 33 as well,
2:15 other
Lordship.
matters, yes?
Item 33 also.
Item?
33.
You're there?
Yes, Your Lordship.
You have objection?
No, Your Lordship.
Yes. 2 weeks, yes. Then we can start it.
Nice.
Huh?
Slightly.
The rest at 2:15. Yes.
Item 31.
What development happened?
Lordship, we have filed an affidavit.
Today?
No, we have filed it on
last
the...
week.
What is the
That
development?
is regarding confirmation, my lord. So my humble submission, these are incident of service, my lord. What is under challenge?
1 second. This with additional affidavit. When is it filed? 4th.
4th of July.
Yes.
My lord, so my lord, that confirmation I have received, my lord, but that will not change the nature of the case. These are all incidents of service, my lord. Tomorrow he'll get a new increment, my lord. These are not the grounds, my lord. I'll satisfy you. It is open to them, my lord. This is not a ground, my lord, that I should bring in a new affidavit and all. It's not required. What is under challenge, my lord, is substantive appointment made in a sanction post. So, my lord, so far I am concerned, my lord, I am ready and willing, your lordship.
Substantive challenge
To the appointment
post.
letter.
The thing is that the order of confirmation.
Well,
So if appointment will continue and then confirmation will not be set aside if you succeed.
No, these are all consequential, my lord. These are incident of service. Once a person substantive.
I have for the college. If I can just draw your lordship's attention to page 17.
70.
17. That's the prayer.
Of the
written
prayer.
That would have a bearing, Millets, in this issue.
It's all because you challenge the recommendation.
My lords. Prayer 2, Millets, may kindly have a look at it. It says, declare the recommendation of the governing body of the Shillong College made by resolution dated so-and-so recommending the name of respondent number 9 instead of writ petitioner as illegal. And then there is a prayer, Millets, down below at serial number 1 for a writ of certiorari setting aside that recommendation. Now, that recommendation, my lords, has fructified into this order having been passed. This order has been brought on record for your lordships, and
You
that
have
is
to
not
challenge
under
it.
challenge.
No, my lords. I'll let him
Okay,
argument.
then
Three,
then-
lordship will listen to me. man.
Then fine.
No,
Mr.
let
Sen,
me,
you
let
want
me.
to go
But
ahead, you
he's
go
not,
ahead.
he's
You
whatever
go
is
ahead.
convenient, he's reading.
You go
I have challenged the
fine.
appointment.
If you want to go one hand, type hand your back, well and good,
No, no, my
continue.
lord. What I am saying, your lordship will see.
You know the
Three.
perils. You're a seasoned counsel.
My lord, I understand. That's
Yes,
why I'm
then.
making my submission. Number three, what I have said, he did not even read. I have said, set aside the appointment letter, not only the recommendation. He's saying only I have challenged the recommendation, not the appointment.
No, I'm not
Which
saying
should
that.
not have been skipped, my lord.
No,
like
I'm
this.
not saying that. I'm saying, my lords, that
I have
there is
challenged
a
the
specific
recommendation.
challenge to
I have challenged the appointment. Now these are incidents of service, my lord. It happens. Tomorrow he will earn an increment. So shall I have to change, my lord, because he earned an increment?
Increment is consequential.
Well,
Now,
this
a
is also
confirmation-
consequential confirmation.
Confirmation is an appointment.
Confirmation
Like
also, my
on,
lord,
on,
this-
a, gov- on a recommendation. Suppose the recommendation list is there. There's no confirmation. What happened?
Well-
Then that your appointment is there,
But he has been appointed. I have challenged the appointment, your lordships. I have challenged the appointment. That these are all.
not succeed in isolation. If my learned senior wants to, chooses not to do that, I cannot.
Yes, he's the master of his brain.
His lordship.
Yes.
Please, Lordship. Lordship, before the council for the
accommodation.
Yes, Lordship.
That is what ultimately- this is what they want.
May the matter be kindly take up tomorrow, my lord. We were ready tomorrow, Your Lordship. Because due to some personal emergency, the conducting council has to leave the court premises. Yes, Lordship.
See, the court is here only, up to your counsel to send it.
End of the day, my lord, what they want, they want to protect the matter,
Whatever
delay
you
the
want,
matter.
Mrs. Sen, the court is
No, no, not
this. Been brought to court. You wish to go ahead?
No, lordship. What I want to submit, my lord, this matter at one point I have pointed out 20 adjournment, my lords. 20 adjournment has been sought, your lordship. At the end of the day, my lord, I am answerable to my client, your lordships. They will ask me why.
Respondent.
And now this, my lord, confirmation, they are taking this plea only to delay the matter. I'll satisfy my lord that it's not required. It's an incidence of service.
Yes.
May I humbly submit? Let my learned senior begin. He's for the petitioner. We can respond.
You want to start today?
What? My lord, I am ready and willing.
No, I won't have part. I won't have piecemeal. Too many piecemeal here in this court.
Only thing I'll pray, your lordship. The next day, my lord. Only. No, I'm not saying this court.
Do like what happens in other situations. Even when we were counsels, suppose a matter that deserves urgent attention, we make a request to the other counsel. Like, look, we have this thing, and after all, we work in the same, what do you call it, institution. Clients will come and clients will go, but then we all brothers and sisters in the profession. So that courtesy you extend each other. It's not a question that you come to a battleground, you're wielding your sword to thrash everyone.
No, it's all right. My
See,
only thing,
it's good that you wear in your sleeve, the concerns of your client. That all lawyers should have that.
No, my
but
lord,
I mean, if there's no more give and take.
No, my lord, this is a question. My lord,
Why today he was not ready because he came with that affidavit, hoping maybe this.
This affidavit was filed when, my lord? Last week.
On the 4th, yes.
Last week it was filed, my lord, affidavit.
Anyway, okay, we'll have it. Then today's Tuesday.
Whatever date, my lord, convenient to my learned friend. I am always willing, your lordship. It should not be adjourned, my lord.
15.
15, my lord.
My lord, your lordship.
Let it be on 18 minutes. 15, 16 will be a little difficult. Reason being,
even the conducting counsel will be out of.
Sent somewhere.
I'm sorry.
18 being long weekend, I might be sent somewhere. That's the only problem. I'm not a master of my own. I'm not a master of my own movement.
No, whatever convenient to my lords.
See, I'm not a master of my own movement also. That's the problem.
Would the last week of July be inconvenient?
Well, this is too far.
That's okay. It's not that. You will have it on 22nd then. Fixed matter.
22nd, all right.
Yes.
Fixed matter, my lord.
From 18th onwards, I'll be on leave up to 3rd August.
How important is the state council?
State is, my lords.
It
is the
state is important, very important. It all depends on the state, my lord. All depends on the state.
23rd.
She will be out.
16, sorry.
Lordship, 16 won't be possible, my lord. I'm sorry, Lordship, because the council has to travel out of the station.
Okay, do one thing. You all work out a date and get to court, master.
If it is not inconvenient, since my learned senior is also coming back on the 3rd, subject to one.
That will be too far, my lord.
4th, we can have it on 4th.
Too far. Let it be on 21st, your lordship.
She's not here. She's out of station. She's going out.
17th to 3rd August.
Yes. Next matter.
32.
Yes, Mr. Datta.
Yes, my lordship. May I please?
May I see that? William, Premier.
The matter is about this assured career progression scheme, your lordship, and after that, modified career progression scheme. And my papers.
You've been deprived of one financial upgradation.
I beg pardon?
They've been deprived of one financial upgradation.
One financial, yes, the first one.
Your grounds that, as for me, synopsis.
Yes,
that,
the first one.
Because when you entered that post, already an upgraded scale, you mean?
Actually, I was appointed, your lordship. I was appointed on 5 July 1986.
Okay.
Yes. That is Annexure 1. Annexure 1, type copy is in page number 15. And at that time, my scale was 550. 550, 25, 750, EB, 200, 900, so and so. Later, my lordship, my scale was upgraded. My scale was upgraded from 550 to 650. And this is with effect from 1st January 1986.
When?
1st January 1986. That is prior to my appointment.
No.
That is prior to my appointment, your lordship.
1 second, just come again, Mr. Datta. You're saying he's appointed on 5
July 1986.
Appointed 5 July?
Yes.
But if 15 says 5th August?
5 July 19.
With effect, okay, 5.
With effect from 5 July 1986.
Right?
86, and the scale was 550.
550, right.
After that, the scale was upgraded. The scale from 550.
No, just that what just now you said was upgraded from 1186.
Yes, from 1 January 1986.
With effect from 186.
Yes, before my appointment.
Okay.
It means the scale was there before my appointment. The effective date is from 1st January. Whereas I was appointed from 5th July.
I mean, yes, okay, you understand. But when this upgradation was done many years after you joined.
Yes, your lordship.
From one,
this come to
186 before you joined. Okay.
Yes.
Now retrospectively, the scales upgraded of all these whatever people who are serving the same category from 186.
Yes.
That means you paid arrears.
Yes.
From the
Your
period
lordship,
of
this the scale, the upgraded scale was counted as financial benefit, financial upgradation. Whereas that is my core pay, not financial upgradation. That is my core pay.
No, you paid 550, then you upgrade to 650. Then what do you say?
560.
550 now
to 6.
550 to 650, correct?
650, yeah.
Then
that is the they have revised the scale. They have revised the scale. They have revised the scale from 1st January 1986, and that first upgradation, that is first, they have counted from my date of appointment. This 560 has been taken as financial upgradation, whereas it is not a financial upgradation, your lordship. It is my core pay. Please come to page 39, Your Lordship.
Why say core pay? Because when you join service, you mean to say that by subsequent action of the university, it was retrospectively, there was already a pay, existing pay.
It is for everybody, yes, Lordship.
Then we'll have.
Then come to page 39, Your Lordship.
Yes.
Serial number 6.
Yes.
A.K. Rathore. Then you come to column 7, that is the date of appointment is effective date of first MACP, Modified Assured Career Progression Scheme. They have given from my date of appointment. Whereas as per the scheme, it is
After
given.
How many years of service are you entitled to a first MACP?
First MACP 10 years after my appointment. 10 years,
So
20 years and
according
30
to you,
years.
Up to 96, you should
Yeah.
get your first MACP.
Yes.
So
10
this is-
years, yes, Your Lordship.
I
10
got it,
years,
got it, yes.
20 years and 30 years. Here they have completed within 20 years. They have given everything. First, second and third. So I have been deprived of one financial benefit, Your Lordship.
Yes. You're retired now?
Yes, retired. I retired on 30 June 2022.
30th June 2022. So what is the financial compensation you're seeking?
I'm seeking this my financial benefit or the first, second, the first one, the first upgradation, financial benefit.
Okay. When was your first upgradation according to you given? Which year was it?
Actually, the first was given in 1986, 5th July 1986. Second was given in 5th July 2006. Then, sorry, Your Honor. The first in 5 July 1986, the second in 5 July 1994, and the third one, that is 5 July 2006. The first one is upgradation, second is one-time upward movement, and this is what I got from ACP, which is no longer there, Assured Career Progression Scheme. That was modified, but that was included here. So I have been deprived of one segment.
How do you say you've been deprived? You retired in 2022.
Yes.
So you should get on 2016.
Yes. And Your Lordship, in the
I'm trying to understand. According to you, you have got 194, correct?
One I got
according to your first
MACP I got according to
according to
me, yeah.
While according to them is your second.
Yes, it is.
And according to you, second one came 2006.
Yes.
Where according to you, it's your first.
Yes. Actually,
Second,
yes.
So now 2016, you entitled another one.
Yes.
That's your case.
Yes.
Okay, please. Okay, elaborate. Let's see.
Yeah.
Your service graph started when 2016.
My service.
The relevant next year, this thing.
I was appointed in 5/7/1986, Your Lordship.
Right. Okay, that you've shown. That's page 15.
Yeah.
Point 576.
Then
and then by order date 15/12/92, upgradation of pay scale.
Yeah. That they did in 1992.
Hmm.
And given effect from 1986, 1st January 1986.
To 1986, the appoint you got the arrears. You paid arrears.
Yeah.
For the financial upgradation.
Yeah.
A substantial amount for 6 years of.
Yeah.
On the higher scale.
Yeah.
You're given the benefit. Okay. Yes. Then next.
Next is, Your Lordship, my prayer is I should not be deprived, and I should get that financial benefit. That is the first one which I have been deprived.
Yes, Mr.
In similar case, Your Lordship.
Yes.
In similar case, I'm coming to that.
So according to you, that first one
come to page
was by not upgradation, is by revision.
come to page 41, it will be clear, Your Lordship.
Yes.
Page 41, Annexure 7. That is serial number 4. A. D. Roy, page 41. Serial number 4, A. D. Roy. It is similar case, Your Lordship. Here also this gentleman, he got his first MACP from the date of his appointment.
Like you.
Yeah, similar. But he got upgradation here. You see in page 43. The type copy is in 44. The last number 2, A.D. Roy. This is the office order. I will read it out. Pursuant to the EC resolution number so and so, dated so and so, adopted by the Executive Council in its respective meeting, and on the recommendation of the 26th meeting of the Screening Committee on so and so, and adjourned meeting so and so, Vice Chancellor is pleased to grant third financial upgradation, that is under MACP scheme, to the following assistant engineers as per details. Yeah, he got. But I have here, it is discriminatory, Your Lordship, the same case.
Where is your name? Upgradation. First MSc. Then this FFU ACP, second 99. Then third MACP. But on column, on let me see, upgradation. He's working as what?
He's working as assistant engineer.
You also assistant engineer?
No.
You are?
Senior technical assistant.
Equivalent to?
Senior technical assistant.
Equivalent to?
Not equivalent to, it is just below the rank of engineer, but the law the rule applies to all. The scheme applies to all. All those whose promotion is stagnated.
We get it. Just yes. What happened to W. Arlindo, number 3? Didn't get.
Who, Your Honor? My Lord?
He didn't get.
Who?
Esa Dokhaj, number 2 also got.
Yeah, but it is not the similar case, but in case of A.D. Roy, it is similar case.
How?
Because he got the first MSCP from the date of his appointment.
His case different because your peer revision came in 86. Now this upgradation of this L.D. Roy, he was appointed in 3885. So this is the scale of pay 22 to 4,000 given 3885 in 3885 only. How is it same?
Yes, he was appointed on 38/1985.
Correct.
And the first MSCP was given in the same year. My point is there should be 10 years service. 10 years, 20 years and 30 years.
Okay, that way.
Yeah.
Yes, Mr. Sen.
Yes, my lord. No, my lord. This is regarding, my lord, financial upgradations. Now, my lord, briefly, if I can tell the facts, my lord. Stagnation, we are not denying. In case of stagnation, my lord, the MSCP came into force, my lord, in 2009. Now, this is the latest, my lord, scheme. Now, as per the latest MSCP scheme, my lord, a government servant facing stagnation in his whole service career, my lord, entitled to 3 financial upgradation, 10, 10, 10. This is
30 years, yes.
30 years, my lord. But, my lord, your lordship will, my lord, keep it in mind, my lords. These are the schemes meant for central government, not for the university. Now, university, unless it is extended by the UGC, my lord, we cannot. Now, this was, my lord, admittedly, MSCP, I will just deal with MSCP, my lord. Ultimately, SCP and MSCP, all these, OTUM, all these have been formally extended by the UGC with its own riders. They have stipulated their own condition. I have annexed. Now, what they have stated, my lord, they stated that the government servant, as per the scheme, entitled 3 financial upgradation, but adjustment has to be made. If there is a financial gradation otherwise granted in exercise of, my lord, cadre restructuring, mass stepping up, like upgradation, these are to be adjusted. Lordship, I'll kindly take my lord to that letter, my lord. I have annexed with my affidavit at page 112, my lord, if I am correct. Lordship has
Yes.
got. Well, I'll just read it. This is 9 July 2000. Extension of modified Asian progression scheme to the non-teaching employees of the Central University, UGC maintained University, my lord. The Government of India, Ministry of Personnel, such and such progression scheme, the central government employees by order. The Ministry of Human Resource Development, Department of Higher Education, in consultation with the Ministry of Finance Department, explained through its integrated finance mission, has conveyed the approval of Government of India by letter extension of MSCTs to the non-teaching employees of central universities, the city centers and institution deemed university funded by the central government, UGC. The ministry by this letter dated further clarified has issued modification in certain. In view of the above, UGC extend the MSCP scheme for non-teaching employees of Central University, UGC maintained deemed to be university, UGC maintained colleges affiliated to Central University and constituted college of Allahabad University, subject to the following condition. These are the conditions, my lord, have been clarified. My lord, 1, 2, I will skip, my lords. Lordship will kindly come to 6. This is very important. 6, my lord. Clause 6. It is to be ensured that in case promotion, personal promotion, time-bound promotion, one upward movement, etc., in situ promotions, any upgradations, Lordship will see the language, any upgradations, my lord, any club restructuring scheme, personal pay scale scheme, any restructuring of cadres, implementation of local cadre review committee recommendation, any large-scale mass stepping up exercise, etc., carried out by the university in the past before 8/4/98 and thereafter, the financial upgradation awarded under SAP scheme such and such, resulting into financial benefit of higher pay scale, have to be, my lord, adjusted against the MSCP schemes. So, my lord, here, for example, this upgradation, when my learned friend was saying the contentious issue, in 92, my lord, that upgradation done, that should not be counted as a benefit under the scheme. That is wrong, my lord. It has been clearly stipulated in the MSCP letter that upgradation, my lord, has to be counted.
That's the only case.
My lord, that is the only case. So, my lord, we have.
Roy?
My lord, Eddie Roy, my lord, that also, that is the post of my lord, assistant engineer. Assistant, but even I'll satisfy. I'll satisfy.
That's aberration.
No, can't be. Can't be.
The scheme applies equally.
No. Now, Eddie Roy, my lord, I could not. My lord, Eddie Roy, my lord, my learned friend has referred to page 41.
Okay, see, adjusted MSCP scheme, notwithstanding the amount of years he served also.
Lordship.
Because according to the petitioner, that means first upgradation he got in 86. What did he get in 94?
94 he got, my lord. My lord, so for 94 is concerned, my lord. 94 he got the under OTUM. That will be counted as second. 94, that is the second.
What did he get? OTUM? One time upward movement.
One time upward
movement.
Okay, OTUM.
That my lord, that has been adjusted. OTUM has been adjusted against the upgradations. Lordship will kindly see against
that
the
has been
upgradation.
taken as MSCP, second MSCP.
Then the second MSCP comes, my lord.
That
Then
means
the
94 second MSCP.
third. Lordship.
Yes.
And then the third MSCP.
Third 2006 he got.
Lordship.
So 2006 MSCP, then 1986. That means that upgradation in pay. That means all, according to your submissions, all these three, whatever financial benefits got over these years in his service, 86 to whatever, that means in lieu of the direct, MSCP has been adjusted. since he got the benefit of pay revision, upgradation 86 from 92, whatever. Then 94 he got one time about movement, and 2006 he got the last MSCP. Yes. Then, if this is directed, have you challenged this? Have you challenged this 9 July 2010?
This order I challenged here.
You challenged 9
Yes, I
2010?
challenged. I challenged.
9 July, you challenged it?
Yes, yes, yes.
Where have you made pleadings?
There is Lordship is referring to that UGC letter. No, not challenge. It's not challenge.
Okay, sorry, FD Roy, what were you saying?
My lord, AD Roy, my lords.
AD Roy, whatever.
AD Roy, Lordship. No, my lords.
March 2015.
Yes.
That is 19 March 2015, Lordship.
No. That's UGC letter is, my lord.
That is challenged here.
No, my lord, UGC letter is not under challenge.
Okay. But it's just this is just a circle. What is it? It does what amount to? A circular, an OM. What does it amount to? Guideline. This 9 July 2010.
My lord, this is Lordship, as I said, my lord, these central schemes are not applicable to the university, my lord. Then, my lord, we will have to University Act.
Usual course is that you adopt a resolution, correct?
Yes,
my lord.
You adopt
based on the UGC.
Based on UGC
recommendation. Otherwise, we are not authorized.
Exactly. You adopt a resolution.
Yes, yes.
Now, where's the resolution?
Yes, based on this
So
condition.
where's the resolution adopted that MACP should be adjusted against?
Yes, yes, it is adopted.
It is adopted. It is adopted.
Where's that? Then what case you have, Mr. Datta? If it's adopted, then it's over.
This is, my lord, this is I have annexed, my lord.
Where's the
division? If there is any division. Madam, I'm just trying to find out.
Within 20 years, they have paid everything.
But you should be happy, my lord. Normally it's 30 years.
At least
we have
30 years.
We have given him the value
10
20
years. 10
20
years.
He would be a loser.
30 years.
Should be happy.
And in that way, they have deprived me of one MSCP.
No, your case hinges on that. If that upgradation you got initially, then that was a bonus for you because you just joined into service and you were catapulted into a higher scale. Okay, that is a big bonus. That bonus you've taken, right? Their case is that since you had a bonus, like before you joined, the pay was upgraded, so you enjoyed that benefit. So,
in case of Eddie Roy, they have passed an order, Lordship.
Where's that resolution?
They have passed an order. Where is that one? Annexure 40. That is at page 43. Type copy as 44. Similar case, Your Lordship. The error lies in the first upgradation, Your Lordship.
Where?
My
Where
core
was
pay.
trying to show the court.
And my core pay, that is my core pay. My core pay is, as I have stated, Your Lordship, my core pay. That is, they have raised from 550 to 560.
Where the
That
650,
650. That is my core pay, Your Lordship. That is not financial
Where's page
upgrade.
is 19 March?
Page 17.
Okay, let's see that.
Page 16, 17.
We will start from there. But if the submission of the sense correct, then 15 March. No. Where's the 15 March you're challenging? 2010. Where's it? Page?
15 March is this one, Your Lordship. There's 19 March.
Okay, 19 March.
19 March. And in case of, yeah,
Page,
19 March.
Impugn order.
38, my lord.
Page?
Page 38 of the writ petition, 19th March.
Yeah.
2015.
That's what I was looking for. See, this order is made pursuant to UGC letter 9710. So then what to do? We'll take down. We'll dispose of the matter.
But pardon?
We'll dispose of the matter.
Yeah.
Do you have any authorities in support of your case? Do you have any rulings to show that such things happened before and some favorable case in your favor?
I have, but no, I don't have here, Your Lordship.
You don't have here, meaning?
Yeah. I'll
You
have
have
to
at
look.
home?
Yeah, I have in my chamber, Your Lordship.
You can't. See, you can't continue hearing like this. You see that. You come tomorrow with the.
Don't dispose of Your Lordship. Please give me a week time. I'll come with
See,
the
so
rulings.
one thing
and all the relevant papers. Yeah.
All relevant papers are here. It's very simple, the case.
Yeah.
It's very simple in the sense that if you just condense the facts, it's very simple. Sometimes PSKs, they think it's very complicated. It's not. This case is very simple. The only stand is that this MACP scheme has been put in place, okay? Where 10, after 10 years, you get a financial upgradation or one-time upward movement or whatever.
Yeah.
Okay. So they have 10 years, you first serve, then you get one upgradation. Suppose there's no scope for promotion, then you get another, you get another final upgradation, then so on and so forth.
30
for
years.
3 times, in times for 3 MSCPs, okay?
Yes.
Fine. What has happened in your case is that you joined service in
19.
I'm going to make it clear for you.
1986.
But just you joined in
86. 1986.
86 August. Correct.
July.
July, sorry. Then at that point of time when you joined, then you continue to serve on a scale of 550 till 1992. Correct.
Yes.
1992 there was a retrospective, upgradation of the scale of the pay at your level.
Yes.
And your scale was enhanced to 650.
Yes. Yes, Your Lordship.
So that was because of the notification in 1992, you got the benefit of added financial benefit for the from the date of your joining till whatever. The next you got another financial upgradation in 1994, one-time award movement. Correct, Mr. Sen? Yes. Then 94 you continued to serve happily. Then 2006 you were given your third one. Now you have been given 3 financial upgradations. Now your only case is that they are not under MACPS.
Yes.
Right.
Yes.
But then the circular of the UGC says that you are to extend the benefits of this MACPS to the employees who are non-teaching employees in the university, and if there are financial upgradations or other due to restructuring of the cadre or something, they give some financial. This should be sort of morphed into the scheme. Okay, so by taking that into account, since you've been given the benefit of enhanced scale from from the date of joining till 94 by virtue of that 92 order, and you've been finally in 94, they've counted that first one, second one give 94 a second, and third 1006 the third one. That's all. Simple case, that's it.
Yes, Your
And so
Lordship.
they say that since you've already availed of 3 financial benefits of upgradation, you're not entitled to any more under the scheme also. Simple as that, if I'm correct.
You're correct, Your Lordship, but there is
Then
a...
okay, you get authority. We'll stay up tomorrow. Oh, sure. Tomorrow?
Yes.
Oh, day after tomorrow.
Today itself, Your Lordship, why tomorrow? Wait for tomorrow.
This is the only issue, my lord,
Yeah.
that's about it. This is the only nothing.
See, if after hearing is still fresh, I could dictate the order now, but.
Lord, you can
give
keep it anyway, my lord.
But the case of
I'll
Eddie
give
Roy.
2 days. Thursday.
I beg pardon?
Thursday.
Thursday. Okay. Oblige.
Oblige, Your Lordship.
35.
MS Agarwal, anything to say? No.
No, Lordship, I am just a formal party in this matter and UGC's notification is not under challenge.
Yeah, okay. Very good. Yes. Oblige.
My Lord, we have challenged the order passed by the District Council Executive Committee regarding the boundary disputes, my Lord. Only confined to one issue, procedural fairness, my Lord. The boundary dispute between the Himam Maharam and the Pawar, my Lord. It has referred to Himam Maharam, Himam Maharam and Pawar, same ship, has gone to the tribunal, and tribunal fixed a date for hearing. And on that day, my Lord, our side sought time for filing the.
Who sought time?
Our party has sought time for adducing further evidence. Now the other side was seeking time to file a show cause reply, and on that day the show cause reply was filed on the next date, and now on that day, my Lord, itself, the tribunal has a dispose of the case, my Lord, page number 32, man, the short issue involved. Yeah, I'm concerned with the procedure of fairness.
Yes.
Well, page number 32 is
you
the.
agree with being part one member?
Yes. Well,
then orders to go.
So as per the Act, there's no such authorization as per the other Acts. There should be more than one member. In this Act, Ilaka is not.
Well, this would not be applicable in this case.
What about that constitutes council rules?
Well, I've run through that. Here the order signed by the CM himself. That's one part of it.
Yes.
Is by the CM himself, Malits. And otherwise also, Malits, that notification, the amendment came into effect in 2024. So, Malits, the orders of 2023. So, even that amendment will not be attracted in this case.
What amendment?
It's to the Ilaka Act, where the delegation of powers, section 10 was inserted, where they said it has to be 2 members.
Yes.
That came into effect, Malits, on October 9th, 2024.
October 9th?
Malits.
That's not on record.
Malits, I have a copy, Malits. I can just place it. This aspect, my lords, I have examined because orders have fallen from my lords on that issue. Section 10 was inserted, my lords. I have another copy. It's okay. So section 10 gets inserted only in 2024. Well, this is prior to that.
You sure about this? Anyway. We'll get a copy.
I can just show my friend a copy of this.
Section 10. Yes. Well, this act was published on my lord 25th September 2023.
24.
Let me go by this.
No, it has to be.
Who is the brief? Maharam.
Notification.
Oh.
Maharam is the party here.
Maharam is the petitioner.
Maharam is a Bhawal. I appear for Bhawal.
Yes.
Sorry, yes.
I am appearing for Bhawal. My friend is here for the district council.
Yes. The date of notification is 4th October. That's correct.
That means he was not there before for the Ilaka Act.
At the Ilaka Act, my lords, ended at section 4. As a matter of fact, I was quite taken aback. All these sections were inserted subsequently, 6, 7, 8, 9, 10. This amendment says that, my lords, insertion of new sections.
Is that correct? I was not aware of it. I thought it was
7, 8, 9.
It was still section 6, my lords. 7, 8, 9, 10 has been inserted subsequently by this amendment, 2024, my lord.
okay. Yes, Mr. Javed.
But that issue apart, my lord, the impugned order, page number 32, my lord.
Page 32.
32 of the writ petition, Annexure 5.
Yes.
Is a order passed by a tribunal. I just read the second paragraph, my lord. The first paragraph, my lord, the order passed by this Honourable Court, my lord, has passed on 18/11/2021. There is also one order, my lord. Now, second paragraph, the case was registered as a tribunal case number such, and the same Maharam, same ship was directed to submit show cause wide order dated such, fixing 5th May 2022 for submission. The same Maharam, same ship submitted his written argument through his counsel on such. Further clarification on the respective stand of the Himas based on documentary evidence also sought. Second is important, my lord. The case was finally heard on such. Both the appellant petitioner is the Powell, my lord friend. Respondent is me, my lord. Appear before me through their respective counsels. The counsel for the respondent pray to allow him to file further additional documents and to adduce evidence. The counsel for the appellant petitioner pray for time till 19 June 2023, as she has to consult her client whether to allow or not to allow for submission of documents and to adduce evidence as prayed by the respondent. On the 19th June, the appellant submitted a petition raising objection to the prayer of the respondent as ample time had been given, and that the time frame given by the Honourable Court's order to dispose of the matter has been since lapsed. They filed a show cause reply. I fully agree with the petition, as from records it can be seen that time for submission of documents and map had been given by order dated such of this court. Again, by such and such, time was allowed for submission of documentary proof up to 26 June 2022. The respondent should have taken advantage of the time allowed, but he failed to do so. Therefore, I shall dispose of the matter with whatever documents, maps, and records available, as well as submission and arguments given by all parties. So, by this, on this day itself, my lord, 19 June, he disposed of the petition, disposed of the case. Now, on that day, the respondent has filed a show cause reply, responding to my petition for seeking for further adducing further evidence. Now, without giving me further time, allow me to go through the show cause also, or to take instruction from the party also. He received the show cause from their side, sent my petition, and he disposed of it. No further hearing. That is the grievance motive. Now, pursuant to that, we filed the appeal before the District Executive Committee, page number 38.
Just come again, listen. Council heard this time was 19 June. So 19 June, everyone submitted a petition.
Hearing was concluded. They made an application for adducing further evidence after the hearing was concluded.
That requires to be heard.
We sought time, to respond with instructions. On the next date, we responded. We said that there was a time period fixed, and that period is already over. Matter has been finally heard.
Yeah.
The one-man tribunal, thereafter took a view saying that since time has already been granted earlier, matter has finally been heard, no further time will be granted for adducing further evidence.
But it didn't file that.
And whatever evidence was on record, the matter is to be decided on the basis of that. It's a question of not a question of no evidence, it's a question of further evidence.
Yes.
Lordship, I'll come to page number 40. 40, memo of appeal we filed before District Council. Page number 40 and para 5. Para 5.
Yes.
In the second paragraph, the Hima Maharam appellant, apart from relying on the documents filed along with his claim petition, also on such, filed 6 documents which clearly reflects the amendment such follows within the Maharam such. My lord, the matter was listed for hearing on 15/6, and on this date, again the appellant filed a petition dated such and prayed for tribunal for allowing him to adduce evidence, including filing of additional documents. A copy of the petition was duly received by the respondent herein, respondent now before appellate court, my friend, and submit that the show cause to the same will be filed accordingly. However, pending filing of the show cause by the respondent herein, the tribunal in a very hasty manner passed the impugned orders and such. It is to be noted here that the respondent duly filed his show cause on such. So on that day, on the 19th June, they filed a show cause. So it requires to be heard whether my application required to be entertained or not. That,
for using extra evidence.
Yes, if he rejects it, my lord, I will take a further course. Now, without hearing that one earlier, I heard you. Now you come up with this application. No further hearing is required, and he disposed of on that day. That is the grievance. And, my lord, being agreed with this, my lord, we prefer this appeal, and the District Council Exit Committee, page number 45. 45. Dismiss the appeal, my lord. Annexure 7. By this order.
Finding is
and I would come to regarding that 148, the second paragraph, regarding that issue, fairness, opportunity. Now, secondly, it says, the contention raised in the appeal that the tribunal has passed the impugned order in a hasty manner is not accepted because, going by the records, the respondent has rightly pointed out that the present dispute is pending before the tribunal since the year 2010. And further, the Honorable High Court of Meghalaya by order dates and such passing.
Where reading from, sorry?
Well, page number 48, second paragraph. Secondly, the word secondly.
Yes.
But secondly, the contention raised in the appeal that the tribunal has passed the impugned order in a hasty manner is not accepted because, going by the records, the respondent has rightly pointed out that the present dispute is pending before the tribunal since the year 2010. And further, the Honorable High Court of Meghalaya by order did and such pass and such has directed the tribunal to complete the entire exercise and to adjudicate on the matter within a period of 10 months. Well, I'll just pause here. 10 months Lordship has given. It was pending because no tribunal was appointed. Not because of me or not because of my friend. Now, an ample time was given to both the parties to file their respective claims and documents. The submission made by the appellant that tribunal has not allowed the appellant to submit additional documents by petition and such is wrong, as the tribunal has given enough opportunity to both the parties to file their documents and adduce evidence. Failure on the part of the appellant to file their evidence and documents on time cannot be taken as a ground of appeal. Herein, the tribunal also time bound to comply with the direction of the Honorable High Court. This is the, my lord, reason of the executive committee. My humble submission is, my lord, once the party come up with the application and other side file a show cause, it requires to be heard. Now, without hearing that one, on that day itself, he disposed.
Your show cause on record?
On record. But, you know, Lordship, if Lordship can see my short rejoinder I filed, paragraph 5 and 8, my rejoinder, I'll just reflect and, my lord, there, my lord, I have highlighted this point more elaborately, my lord. If I may read, my lord, that when the matter came up on 19 June, madam,
it's only on procedural infirmity.
Procedural only, not on merit.
You say procedural infirmity.
Yes,
the matter should have been heard.
Right. That is only my grievances. But whether I have evidence or not, or my friend has evidence or not, that is up to the tribunal to decide. But on the procedural
admissible or not? Only on that point.
Only that issue. That is the issue.
After the matter is both parties have filed their respective evidences. Matters heard. Then Millard's a plea is there for adducing additional evidence, filing additional documents. That is rejected.
No, that was...
And there is no separate order.
No. The thing is that he'd file the application and then you'd file the objection.
Valid.
And you file objection to the show cause.
No, I did not file, my lord.
You filed show cause objection rather.
Yes, he filed a show cause against my application.
He made the application for adducing additional evidence.
Oh, you filed a show cause?
Yes.
And the matter was ended there?
Ended there.
The court rejected the application for
there is no separate order of that miscase, the application filed by me.
No, you don't go by strictly technicalities we can overlook. I mean, just the broader aspects only that,
yes.
Only person that justice or not.
Right,
the procedural infirmity should not
be
to such an extent that it clears clearing the face of the record.
That is the core issue.
Matter now?
Disposed of.
By this order, it is disposed of.
Disposed of.
So my humble...
So you're not questioning the order merits also?
My lord, I have challenged both.
Has it gone to merits?
Yes, the order is speaking order, Millards.
Tribunal.
Yes, Tribunal and Executive Committee, both are speaking orders. They've traced back records till 1938.
On merits also, challenge is there, my lord. But now, my lord, I'm...
The order of the Tribunal and of the CM will challenge on merits.
On merits also, I have challenged.
Then we'll look at the merits also. You mean this point is infirmity is a side point?
Yes. Yeah, this is one of the main points.
One of the grounds of your challenge.
Yes, yes.
Okay, I thought only on this ground. Or other grounds are there?
Other grounds on merits also.
On merits, my lords, I have not seen anything much on merits. I don't know if my learned friend. The pleadings are silent on merits.
It is.
The writ petition is silent on merits.
My lord, if I just point out my writ petition,
Where
para,
is setting aside
9,
notice to
para
orders?
7, 8, 9, and then. My
No,
lord, I
let's see
have
your prayer. Okay, 79. You see your pleadings, yes.
That's 7 at page 6, my lords will kindly see.
Oh. This opportunity I have pleaded, my lord, with regard to, my lord, para 10, my lord, may come straight away.
These are very generalistic pleadings, my lords. These are not specific to the findings of the tribunal. The tribunal has come up with specific findings. I can take your lordships to the findings of the tribunal.
Well, in this,
9, they say, my lords, violation of principles of natural justice. 10, they say, my lords, is a very general kind of a pleading saying the respondent has passed the impugned order
10.
merely on documents of respondent number 6 and without considering the factual aspects of the matter and as issues pertains to the incident are matters of importance and requires in-depth inquiry. No inspection or inquiry was conducted. So and so before passing impugned orders, which authorities ought to do so as to enable them to ascertain facts and counterclaims. Very, very general. I can take your lordship, if your lordships, my lords, we can go back to the entire merits of the matter. What are the findings of the tribunal, my lords, which have been affirmed by the executive committee, and whether there is any specific challenge to that?
Now the demarcation matter, correct?
My lords.
It's been put on the ground, implemented.
Implemented, but it's been there. This has been part of Ball citizenship for a long time.
That is a dispute. That is a dispute.
These villages, Millers, the Tongpleng village, it starts with the Tongpleng village, that's been within the jurisdiction of Ball citizenship. There's documentation on record to show that. That entire aspect has been gone into by the tribunal.
Fact, that's the only thing. If this only limited prayer you have, that what evidence is so important, which can why didn't you put it in the first instance when you had an ample opportunity?
Well,
was it discovered later on?
But
also always in your possession.
Well, some documents were ready to produce.
That application or the evidence which they ought to have wanted to bring before the tribunal, millets, that also is not part of the record here.
Here in the writ petition, it's not here.
It's not part of
the. It must be part of the tribunal.
Let's see
where is
the application. Let's see.
It's not
here. Discovered fresh.
That application is not here.
That can only be consideration.
Only
if we apply the general rules of evidence, whatever. I mean that there will be additional evidence to be adduced. That means.
But only my concern is that procedural fairness.
You feel that the evidence that you would have adduced would have changed the outcome of the entire matter?
Would have a bearing.
100%.
Would have a bearing, madam. That is why, otherwise there is no question of delaying the matter. Both of us are contesting before.
If we allow your prayer for adducing additional evidence, that means it overturns the entire tribunal findings and also
it sets back the clock to not.
With profound respect, if Lordship accept my argument, then my Lord may direct the tribunal.
See, the thing is that we are not sitting the appeal over the orders. We are just looking if there's any procedural irregularity or illegality, which needs to be corrected by directions from this court.
Right.
Now, the only procedural irregularity you say is because they had filed a show cause to your application. That was never heard.
No, never heard. That is
and without hearing, it was disposed.
Disposed of. So, if your Lordship entertain my petition, directed one tribunal to hear my the application and his show cause.
No, it's been rejected.
If he's not satisfied, he can reject it.
No, my lords, it's been rejected.
No, there is no speaking order.
Where's the rejection?
I'll take your lordships to the at page 32, my lords. What my learned friend had read at paragraph 3, Annexure 5, paragraph 3.
I'm sorry.
Paragraph 3, page 32, my lords.
Oh, 32.
My lords, have it, my lords. May I read paragraph 3? The case was finally heard on 15/6/2023. So hearing is concluded on 15/6/2023 minutes. Both the appellant and the respondent appeared before me through the respective counsels. The counsel for the respondent prayed to allow him to file further additional documents and to adduce evidence. That's on 15/6/2023. The counsel for the appellant petitioner prayed for time till 19 so and so, as she has to consult a client whether to allow or not to allow for submission of documents and to adduce evidence as well.
6 was over.
Hearing is concluded, my lords.
Then after that, after the hearing is concluded, the counsel said, "Let me."
I want to bring in some more documents. No. Now, whether that would be permissible in law, my lords, and the finding is down below, my lords. On 19 June, appellant submitted a petition raising objection to the prayer of the respondent, as ample time had been given and the time frame given by the Honorable High Court order to dispose the matter had since lapsed. I fully agree with the petitioner, as from records it can be seen that time for submission of documents and maps had been given by order dated 29/3/2022. So that's almost a year and a half back. Again, by order dated 31/5/2022, time was allowed for submission of documentary proof up to 23/6/2022. The respondent should have taken advantage of the time allowed, but he failed to do so. Therefore, I shall dispose of the matter with whatever documents, maps and records available, as well as submissions and arguments given by all the parties. I have heard the parties concerned and perused the numerous records, documents and maps submitted by both the parties in support of the claims. I have also gone through the written arguments of both the parties.
But it's over, Mr. Even written arguments have been filed.
My lord, on the 15th June, my lord, it was fixed for final hearing. Therefore, I come up with the application for seeking opportunity.
It says the case was finally heard.
My lord, that is the, my lord, they have mentioned this. My lord, but admittedly,
question that.
My lord, if the matter was fixed, already heard on 15th, there is no question for me to file an application for adducing further evidence.
Well, that's not correct. I'll take to my learned friends
regarding this,
a woman's at paragraph 7.
Case,
my lords, can I have a look at paragraph 7
no
once of the writ petition?
You bring an application where you file for additional letter.
My lords, if I may just take your lordships to paragraph 7 once.
Of the pleadings. You bring it tomorrow?
Of the writ petition.
I don't think, Mr. Chandra, so we can...
Just have a look at paragraph 7, my
It's a
lords.
very bad precedent. Yes.
Just 1 second. 1 second. My lords, that pursuant to the directions issued by this honorable court, my lords have it.
Yes.
Notices were issued and parties entered appearance through the councils and filed their respective claims and counterclaims in respect of the said dispute. Further, on 15/6/2023, when the matter was heard, so that was after the matter is heard, my lords, the council filed an application.
That is one.
So that's part of his own pleadings.
You bring the
I can bring the, my lord, the application if required.
But I don't, Mr. Chandra, so we don't want to tamper so much. The thing is that, you see, it's a very bad precedent. So any other preceding, then when it's done, but that is,
I would like to, regarding the additional documents, in the appeal they have raised the same thing, regarding the additional document which they were not allowed. In the appeal it's allowed. The additional document is there in the appeal. Kindly come to page 49, Lordship.
They have taken into consideration.
Yes, they have taken into consideration. No, in the order passed by the EC. Page 49.
The thing is that, Mr. Chareso, like talking outside the case, the duty of the court to see the fundamental principle judicial procedure are followed. It's a quasi-judicial body.
Yes, exactly.
You know, it's like that.
Exactly. With the fairness is done.
Yes, fundamental principles that you've been heard. You know, it's only a slight, irregularity which you say that has whatever like infringed upon your rights.
Page 49.
Yes. 49.
Page 49. Starting on the top.
I can bring the application.
Last 2 lines.
Yes, that does. Yes.
The last 2 lines. The appellant has given an opportunity. 49 top.
Yes.
The last 2 lines of the first paragraph.
Yes.
The appellant has been given an opportunity to file the additional documents through the Nyau, Kanthai, Snaitang, and the argument made by the counsel. The appellant has been taken into consideration. Now, what are these 2 documents? Towards the end of that page 49, there are 2 documents brought. Can you see, Your Lordship? The third line, the third paragraph.
Yes.
1, 2, 3, the marriage certificate. That is one document dated 22nd January 1958, submitted by these 2 members of the Nyau, Kanthai, Snaitang, has no relevance.
You want to introduce these documents?
There's one document, and the other document was there's an election ID, the voter ID. That's it. These are the 2 additional documents.
These are 2 additional
I'll bring my lord. I'm not sure whether this is the document.
That's why this court wants to see what documents want to introduce.
No, I'll bring on record, my lord. Day after tomorrow, if lordship keep.
Not your ration card or something like that.
Exactly. Day after tomorrow, if
Yeah, day after
Since I
tomorrow.
come,
I'll have some difficulty day after tomorrow.
There's nothing. Only
tomorrow,
that.
on Monday.
Tomorrow.
But with the party can come from Maharam.
So we have the copy of the application.
Friday.
So we'll try.
Friday.
Well, it's Thursday and Friday. Well, I have some difficulty.
Where's your assistant counsel? She can handle it, no problem. Yes.
My lords, my kindly excuse me.
Yes, day after tomorrow.
Your Lordship, the thing is that district council is facing problem because why the census is going on. Now, Tlong Preng is now, the census is not been taken up. Because there's a dispute within the Ilaka. Now, Maharam is saying it's theirs, Bohal is saying. So now the census is affecting. So it has to be taken up.
Friday.
Has to be decided. Thank you.